my congratulations to Oman Center for this first inaugural conference, which is so well done. I'm very impressed. You know, I've spent a lot of time attending conferences, but this is one of the best I've attended. Quality is very good. Now, going back to construction contracts, construction projects, I think it ranges from a house to very large projects. So one of the problems is that I think the issues will be the same. Sometimes the house problem is more painful to the individual than let's say a very large project. But there's a sense of ownership. There's always a sense of ownership that causes the trigger. Because when construction contracts actually go bad, there will be disputes, maybe issues coming out, and then there will be an idea that we have to deal with it in a very, very aggressive way. Perhaps terminate, that's one way. Perhaps bring the dispute to the fore. You know, and it is always that trigger point that makes it, I think, people forget, and they only look at that event. But in reality, when you start to embark on such a thing, you cannot go back. Very difficult to go back. So I think one of the things that when someone tells you we have a dispute, we have differences, we need to actually exercise the contract, apportion the blame, then you have to actually first look at the case. You have to look at the case and look at the issue and whether it needs to be done that way. I think people always forget. They always look at their claim and say, my claim is the most important thing. They forget the counterclaim. Who could be the real claimant in that kind of issue? So I think the early case evaluation is one of the things that many clients don't do. They sometimes just listen on what the formula is to solve this problem. And I think they sometimes overstate with great confidence their case and understate the case of the other party. And I think the second thing is that sometimes when lawyers go through the documents and all this, they will tell you a good case, but you have to ask them. You yourself should know there are certain requirements that have to be met. Case requirement, notice requirements, there is certification requirements, whether you have breached in turn. So normally there will be, let's say, if you claim a breach, he claims a breach, at the end of it, who actually is right. And whether you terminate, whether it's a correct termination or whether it's unlawful termination. And that's where the issue is. So I think notice provisions are very important. For example, certain kinds of breaches require notification and time frame. So there is a procedure that has to be followed. So you have to follow that procedure. The next thing about construction contracts is records. The problem of records is you don't know what you have until the dispute starts. Then you will find there's a great scramble to identify, I need this record. Why is this not kept properly? Why is this not kept properly? Where is this? Then, oh, this person has resigned. So I think one of the things that you have to actually assess at the moment is what is the baseline evidence that you have. Very important. So I think you need to actually bring an outside person to assess it. It should be the lawyers, but sometimes that may not be good enough. Maybe a person who does documentation. Then, one of the important things is that many clients don't have strategy. They have an intention, but no strategy. So I think at that point of time, you have to decide whether maybe it is better to settle it, better to look at other methods of how we can actually resolve it instead of going on. Maybe try to maintain the relationship. Then I think that is the real problem at that point of time. Is this the first time the client will be looking at the arbitration clause? When you are actually talking about giving out the project at all the stage, you never look at the issue of dispute. you tend to put it at the background, I want to get this thing done. So you have to actually decide where is the arbitration held, what is the procedure that's going to apply, what is the applicable law, what is the substantive law, and then you must be very, very careful that whether you can be jammed in such a way that jammed up means basically you can't go on. There can be roadblocks put in to continue the arbitration. So normally that's why the procedure and all these things become very good done. The next thing that is very important is getting the right team. Sometimes you need to actually bring in a third party. The team that is advising you, it's all right, but you may need to actually assess it through an experienced team, tell you that whether there's a good case or not. There's an independent audit kind of arrangement. And then from the beginning, you must formulate your case properly. The case must have a theory on how, because arbitration is about apportioning blame. And after apportioning the blame, how to assess the quantum of damages. That is the real serious issue, because you get the liability apportioned. After that, you're unable to prove your quantum. So I think that's what I would suggest that parties look at when they go into arbitration.
Thank you very much, Professor, and I agree with you. And also in construction cases or construction arbitration, there is a new trend of using the technology means in terms of helping the team to prepare a good case, particularly, as I said, there's a big volume of documentation, and going through this documentation can be now enhanced through the use of technology, of screening these documents and extracting the right evidence. So thank you very much for this. Maybe now I turn to Asmoel. With your experience in financial institutions, particularly contentious and non-contentious disputes, what do you think the best strategy to adopt before you go whether to litigation or to arbitration from a financial institution point of view?
Thank you so much for the question. And I think that the answer will have a lot of similarities of what my colleague here had already mentioned. But I would like to address this by splitting the matter into two stages. The stage before the dispute had arisen, and the stage when the dispute had already arisen and you are managing that one. So because we are in business, and because you do not have, and you will not have only one dispute, you are prone to, by the virtue of becoming a financial institution, you are prone to a lot of legal liability and risk and all that. You have to be really, really ready and prepared. And one of the gurus of banking said that bankers are in the business of being prepared. So before you have a dispute, you will have to make sure that your contract is robust enough and comprehensive enough, and that you have a multi-tiered kind of dispute resolution clause, so that you do not jump into litigation or arbitration or forced to be brought into that just like that. And then once you have that as an in-house counsel, I think it's extremely important to also make sure that you have a robust contract management process, and you are actually part of that contract management process. And that process should also include ensuring that you have all the records, the emails, the correspondence, the letters that were sent, the expert reports, whatever was issued, because that is it's only at that point of time, just like my colleague said, you will be looking at the documents and all that. The other aspect which I think it's very important is that you should always maintain a direct and transparent kind of communication with the counterparty, because this is how you can actually manage the relationships. This is how you can avoid conflict, and this is how you can manage disputes as well. For financial institutions in particular, I think it's extremely important also to have a complaint monitoring kind of a process or a system, because that will help you understand what are the major themes that you see, be it in a product or in a service, and what are the legal risks that may arise from this product, so that you can prepare for this from the beginning. So this takes care of the stage that is prior to the arising of the dispute. Once the dispute had arisen already, I think I agree with my colleague, the first step that you will need to do is to make sure that you assess your legal position. And for you to do that, you will have to definitely get your facts right. You will have to look at your records. You will have to speak to the relevant stakeholders. And then if you need an external support of a lawyer, of an expert, you can definitely do that. But in a nutshell, you have to form a legal position, and you have to understand your legal position and your legal risks very clearly. I think once you have done that, then you can, and because banking is also a business of relationships, I think it's extremely important that you start with negotiating with the counterparty rather than going straight to issuing legal notices or doing anything like that, okay? So, and you have to make sure that during negotiations, you have the right audience in both sides of the table, be it the legal minds or be it the decision makers of exactly, the business team, the decision makers in the process. And then you will be negotiating based on the legal position that you really understand very well. And then depending on the outcome of the negotiations, you will decide whether to settle or to go for litigation or arbitration, as the case may be with the dispute resolution clause.
So I think with the characteristics that you describe, you can see, or do you see more of settlement attitude rather than going to contentious because of resolving these disputes? The relationship that you talked about, the sensitivity that you talked about, and also from assessing the case, because sometimes settlement can be a good option rather than just go to litigation.
Yeah, I think settlements are, just in the previous session,
Exactly.
a colleague mentioned, I think that was Abdul Wahab Al-Hinai, our colleague from OQ. He mentioned that a senior industry expert told him that a bad settlement is better than a good arbitration award. So I think settlements are always welcome, so long as they make commercial sense.
Not necessarily we agree with this.
Yeah, absolutely. But because ultimately we are in the business of making money, so so long as a settlement makes commercial business sense, I think we should go for it.
Thank you very much. Mr. Mansour Jamal, the role of national court is very important in arbitration. Throughout the process, from the beginning, ruling on the arbitration clause, the validity of the arbitration clause, if needed, appointment of arbitrators, if needed, during the arbitration, interim measures, or after in terms of enforcement. So the question is, how do you see the approach of the national court here in Oman towards arbitration, whether is it supportive or non-supportive? How do you see the interaction should be between arbitration tribunals and the national court?
Thank you, Fahad. And I'd first like to thank the Oman Arbitration Center for having organized this exceptional inaugural event, and we look forward to many more of these taking place in the future. The question that you raise, it's an important question, given that arbitration itself is evolving and developing in Oman. And if I was to answer the question in its short form, I would say that the Omani courts have been very supportive towards the development of arbitration. And perhaps that, to some extent, is brought out by the number of arbitrations that we're seeing taking place in Oman under the watch of the Oman Arbitration Center and the ICC-based arbitrations being seated in Oman. I'd like to, however, just go back in history a little, in the sense that Back in 1981, the Authority for the Settlement of Commercial Disputes was established out here as a court, but it didn't comprise of qualified judges. It was primarily members of the business community who were identified by the Oman Chamber of Commerce and Industry to preside over disputes. A civil and a commercial procedure law had also been introduced in 1980 at that point in time. And neither the law that established the Authority for the Settlement of Commercial Disputes nor the civil and the commercial procedure law had clearly dealt with the issue of arbitrations as being an alternative dispute resolution mechanism in place of the Omani courts. Despite the absence of such a regulatory framework in place at that point in time, members of the Authority for the Settlement of Commercial Disputes, when confronted with contracts which provided for the resolution of disputes between the parties through arbitrations, respected the content of those agreements and preferred not to intervene and interfere in that process. Going forward to 1990-91, the primary commercial court was established. Again, there was no formal arbitration law in place. We were still working on the commercial and civil procedure law that was in place from 1980. And again, whenever cases came up before the primary commercial court, which involved arbitration provisions where the parties had agreed that their disputes would be resolved by arbitration, unless both parties consented, the commercial court didn't assume jurisdiction. Moving forward to 1997, when the Oman Arbitration Law was introduced, we had a comprehensive arbitration law which provided for the rules and regulations and the framework within which arbitrations would be conducted in Oman, and provided for the autonomy of the parties to the arbitration for the conduct of their arbitration proceedings. By this time, the appeal court had come into existence and the Supreme Court was about to be established. Each of these courts have consistently upheld the right of the parties to have their disputes arbitrated upon if that is what they've agreed to. What the courts then realized was that their role thereafter was going to be more of a supervisory and a supportive role. So if the parties were not able to agree upon the selection of their arbitrators, applications could be made to the court would assist in the selection of the arbitrator. If any interim relief was required, the court would take on the responsibility of providing that relief, provided it was consistent with the terms and conditions of the parties' arbitration agreements. So I believe that although I've referred to the last 30, 40 years, we've been able to see that there is a pattern, there is consistency in how the court has conducted itself over the years. Where the courts perhaps have not been as supportive, and possibly for the right reasons, is where the agreement to arbitrate itself has not been very clear in terms of what the parties may have intended and what they believe they've provided for in that agreement. Under those circumstances, it was incumbent upon the court to intervene and to make an interpretation of the arbitration clause, and if it was just not workable, they've had to assume jurisdiction. Secondly, they've had to consider whether or not the agreement itself is binding on the parties. Has it been entered into fraudulently? Is it something that's being suggested as having been entered into orally? Or does it relate to the arbitration of a dispute between the parties, which in accordance with Omani law just cannot be arbitrated upon? So for example, if it's a criminal matter, if it's a family law related matter, public policy related issues, these aren't issues that the Omani law allows for arbitration in Oman. In terms of enforcement of foreign arbitral awards, yes, there are limited circumstances under the Oman arbitration law which allow for the arbitration awards that have been issued to be challenged. But again, the courts have not overstretched themselves in terms of offering broad interpretation. They've tried keeping themselves within the framework of Article 53 and the grounds for nullification that have been provided for there in terms of determining whether or not the challenge should be accepted or not.
And do you see an increase of the enforcement of foreign arbitral awards?
I'm sorry?
Have you seen an increase of enforcement of foreign arbitral award? Because I think most of the GCC countries now, we tend to see an increased number of enforcement of foreign arbitral award at the back of the New York Convention?
Yeah, so with Oman having become a signatory to the New York Convention and with a lot of international arbitrations which involve Omani parties and foreign investors, these arbitrations are taking place overseas, and awards that are being issued there are being brought back to Oman and are being taken through their enforcement process. Has the enforcement process been as expeditious as we would like for it to be? Perhaps not. But I think, we are going through our learning curve. The experience is being developed for future enforcements to take place.
Thank you. Very much. Maybe back now to Professor Chandra. In construction disputes, delay and quantum is a critical point. And normally, in construction disputes, it's about who caused the delay and what is it worth. Responsibility of the issues of the delay and what is it worth. In your experience, what do you expect or would like to hear from a delay and quantum experts, both in their report and also in their witnesses and their evidence, from your experience?
I started, I had my first arbitration in 1990. So I still remember at that time, most of the arbitrators in the construction industry were actually technical people. You're either an architect or an engineer or a quantity surveyor. So I think that's how it all started. And the arbitrator was allowed to use sometimes his own knowledge. The rules started to change once lawyers started, because I think lawyers appeared before the tribunal and said, look, no, he used his own information that he has, his own knowledge, he understood the thing, but we didn't submit any of those things. So I think this is where really it all started. In fact, I think now even Doug Jones, in his last lecture, suggested maybe it is too many lawyers handling construction contracts and not enough technical people involved. I mean, it's going back that way again. But coming back to it, in construction, because it's so much records, complication, who say what and all these things, really it comes out to establishing the facts and what those facts mean to the arbitral tribunal, which could be a set of lawyers. All of them are lawyers because they don't understand. For example, if you go to a judge and you explain that ground conditions are not stable, we need who is responsible for the investigation process, or who undertakes the warranty, or whether the ground condition, if the client is given some information. So there are three types of experts that you will see in construction. One is the technical person who will tell you what is the technical information that you need to know and what it means. One of the things about arbitration disputes is that you are reconstructing the entire project after the event. That means you're doing the project from day one, who did what, who did what, who did what, who didn't do what. So it is a reconstruction ex post facto, after the fact. So your factual witnesses are very important. Your documentation is very important. And I come from a common law system. And in a civil law system, common law system, everything follows the law, the contract. Basically, you cannot deviate. There is no power to decide in equity how people behaved. But of course, there is merging now. The two rules are merging, and the way taking evidence, like we are using the IBA rules all the time. Now, the real thing is that first question you ask yourself, whenever I have an expert evidence, the parties will inevitably say that this is a complicated thing. We want it to be explained by an expert. So it's a technical expert. The next thing will be a delay expert. You will find that inevitably everything goes on timelines, delay. Third type is quantum. At the end of it, everything must be put down in terms of monetary terms to calculate that. So basically, first thing, do you need an expert? Your team will tell you you need an expert. And then what kind of expert? I think the experts, everybody now, I mean, if you are in construction, you will find that one of the procedural order number 1 will have to deal with experts. You will have expert reports coming in and all these things. Now, the problem basically is that the experts are employed by the party. So the question always arises, how independent they are. What is their duty to the tribunal? Because they are paid by the party. You see, for arbitrators, it's a bit different because you actually declare your independence, you say you're impartial, and then after that, you don't communicate with the party who has nominated you, or you don't communicate with anybody except through the president, if it's a 3-man tribunal. And it is always done in writing in an open manner, transparent manner. Experts are in deep discussion with the parties on to find out what the facts are. So I think one of the real problems is the question that comes to the tribunal's mind, is this expert going to help me, or is advocating the party's case? So that is the barrier that you have to deal with. And inevitably, like what I do, tribunals that I chair, or as a sole arbitrator, normally I will remind the experts, and I will tell the parties, I will tell the experts that their primary duty is to the tribunal and not to you. Although you're employed to present the thing, your information must support me. The moment the information does not actually help me to come to a right decision, then there is some credibility problem. So I think for parties, it is sometimes very, very good to identify the experts that have credibility. They must have the qualification. All experts must have qualification. Basic qualification you must have. Advanced qualification sometimes. And you must have the experience, many years of doing that kind of thing. The next thing that I think tribunals try to do nowadays is, let's say for delay, we actually tell you what method are you going to use. You see, I just did, I'm chairing a recent arbitration, and we all agreed that at the beginning of the pleadings, after the claim and defense is filed, the experts will then tell us what method they will use and the reasons for it, and then we will choose one method after that. So I think that is also very important.
So that's both in delay and also in quantum as well. What kind of methods?
Quantum is a very interesting thing, because quantum, the problem is the arbitrators are bound by the law. They must decide what parties submit. You find that always now, the courts in developed jurisdiction, while they don't set aside for excess of jurisdiction, they always set aside the award for breach of natural justice. That means the parties never submitted. The most recent case is a petrol Viet in Singapore, SIAC, very, very distinguished tribunal. It was set aside for breach of process, natural justice. Why? Because they came out with an answer that was not submitted by both parties. So I think, again, the experts come in to help you for quantum. Now, what do the tribunals nowadays do? Because we have to choose, normally when you have experts, let's say by the claimant and by the respondent, they never merge. They may have divergent positions for certain items. Certain items they will agree, but many items. So what the tribunal will do is that first, can you agree on the item? What do you agree on? And it is common, this is whatever the figure is there. If liability is found, that is the figure that is given. The second point is that tribunals are going one step further. They are actually telling the experts this. I want you to meet, and we are instructing you to look at the other side's figure and look at the reason why they asked for. And even if you don't agree with it, what will be your figure? figures as figures. So that has become now the norm. So the arbitral tribunal has a figure for both sides. So when the quantum is done, liability is actually apportioned, the quantum is quite straightforward. So there's less a chance of having that. So I think that it is good to tell the tribunal who your experts are early. And I think the next thing is to actually have a methodology. The methodology must be actually driven by the tribunal. Thank you.
Thank you very much. Very comprehensive answer. Maybe, Al-Samawil, after your first introduction regarding how to avoid going to contentious, now for the banks, on what basis or what is the grounds that the banks would normally go and choose arbitration as opposed to any other means?
Okay, thank you so much. I think the short answer will be it depends, but there are general themes which I can share. At least this is what we do. I think arbitration is not for your consumer kind of loans. It's not for your retail kind of loans. And I think this is something that we as banks or banking community may need to discuss both with the Central Bank of Oman and maybe the center, the Oman Commercial Arbitration Center also, to see, because it's an opportunity. It's an untapped area maybe. So arbitration is not for that. Also, arbitration is not for because of the cost that it entails. It's not for low value kind of claims, even when it comes to your wholesale banking kind of disputes. So courts are better suited for these kind of disputes. Also, whenever you expect that your counterparty is somebody who is not going to be cooperative, then you may think of going through the court process so that you can use the force of the court rather than going through the arbitration process. But other than that, I think arbitration is definitely the right option for your syndications, for example, especially when you have members of the group from overseas. It is definitely a good option for your M&As, and it is definitely a very good option when you have a complicated matter, a structure that's really complicated in its nature and that requires certain expertise. Then you definitely have it. Another consideration is where you really are keen about confidentiality, and that's always the case with banks. So arbitration is also sought after for its confidential nature and so on.
Thank you very much. I was going to ask the same question to Mr. Mansour, but Samuel answered the questions. Maybe I'll go and I'll go to, given now the infrastructure projects that's evolving here in Oman, do you see a trend moving to arbitration related to this projects, given the growth of the number of projects in Oman, particularly talking about the mega and giga projects?
Thank you, Fahad. I think, given that Oman had embarked upon its privatization policy about 25 years ago, it was one of the first countries in the region to start privatizing certain key assets, such as the power assets in the oil and gas sector, and these projects attracted a significant amount of foreign investment into Oman. The foreign investors coming in obviously had their own requirements in terms of how the projects were going to be structured, the complexities, the multiple parties that were going to be involved, the funding that was going to be required for those projects coming in from lenders overseas, in addition to the domestic lenders. It was just considered to be natural for the project agreements and for the financing documents to provide for the resolution of disputes by arbitration. Similarly, with the Vision 2040 that Oman has embarked upon, again, that's given rise to significant high-value infrastructure projects being developed, particularly in the transportation sector, in clean energy, hydrogen, and again, for the same reasons that I've referred to earlier on as to why arbitration was considered to be necessary. These projects have also provided for the resolution of disputes by arbitration internationally, overseas, and now increasingly with the Oman Arbitration Center having been established, the possibility of the arbitrations being seated in Oman as being seriously considered. What is also happening is how the arbitration clauses are being structured in these agreements, that you have potentially two-tier arbitrations. So if it's a high-value arbitration, it's going to be seated overseas. If it's below a specified sum, then the arbitration proceedings may take place in Oman, either through the Omani courts or subject to the Oman Arbitration Center rules. So the good thing is that not a lot of these projects have gone wrong, and therefore we've not had to test some of these mechanisms that have been put in place. But where arbitrations have taken place with regards to construction disputes, we found that the results and the structures that have been put in place have generally been accepted. I think going forward, what is likely to be interesting is how the new investment commercial court functions and operates. It's going to present potential challenges, in my opinion, to arbitration, in the sense that the time period within which the commercial court is required to decide on its cases is specified to be 6 months, and under exceptional circumstances, that time period may be increased. The cost of litigation is still going to be potentially cheaper than what the cost of arbitration may be as well. Thirdly, the judgments that come out of the commercial court are likely to be reported, so it will allow for some level of certainty and consistency in terms of how future transaction documents, project documents may be structured and negotiated between the parties.
Thank you very much. Thank you very much, and I really thank you for finishing on time. When the clock turned to 0, you stopped the answer. So thank you very much for this session. And I think we stop here, and we welcome the audience for any questions. Anyone wants to ask questions, so we can address it to the, please just here. Maybe state your name and direct the question to any of the panelists you want.
بالعربي ولا بالانجليزي؟ عشان بس نترجم.
السلام عليكم. Dr. Fahad, my question is to you. Under the law on arbitration, awards remain confidential and they're not publicly disclosed. What was the legislator's rationale behind this? And in your view, would greater transparency through publishing such awards enhance our understanding of the reasoning behind certain decisions?
So thank you very much. I mean, I'll answer the question, but also I invite any of the panelists to add on. I think the main characteristics of arbitration is confidentiality. So why we go to arbitration, not to go to litigation? There are certain characterizations that are known and privileged to arbitration. One of them is confidentiality. So parties tend to go to arbitration because they chose to have a forum that is confidential. They don't wish to disclose. However, is it possible? Yes, it is possible, but it requires the consent of the parties. It's two actually ways. Either parties are consenting to disclose the award, or there is a rule, there is a law in the jurisdictions that allow. But I don't think yet there is a law from a national level that state that, because it will lose its competitive advantage of losing the confidentiality part. I know now there are a couple of arbitration centers that they encourage, and they encourage parties to consent for such disclosure. Yes, I can see the point that you are raising. I think once arbitration awards are disclosed, I think the level of quality will be enhanced. The scrutiny is going to put pressure on arbitral tribunal to make sure the reasoning, the drafting, and the award is going to be under scrutiny. So that is going to increase the level of the quality. But to answer the question, I think there will be a challenge to make it as part of the law, in order to make it publishable. But as I said, ICC, LSEI, both reputable institutions, they allow for parties to consent to that. That's my view. I don't know if anyone wants to add.
Can I chip in?
Please.
Actually, there are three concepts involved. One is confidentiality. The second one is privacy. The third one is transparency. Now, first thing is that confidentiality is basically to bind the parties and the tribunal as to the secrecy of the proceedings and the documents that are produced in the proceedings, so that it cannot be used for any collateral basis. Because sometimes some evidence will be showing. I give you an example. If you are a bad paymaster, do you want the whole world to know? I'm quite sure you don't want anybody to know. At the same time, if you do bad work, do you want the world to know? I don't think so. So I think that is one reason why people choose arbitration. The second one is privacy. Arbitration is not a spectator sport. Unlike the court, you can sit in the gallery and watch the entire proceedings. Next day it will be reported, but almost guard comes close to it. I think DAR actually gives more information about certain arbitrations that are going on. Then the third thing that is really happening is that arbitrations are becoming so big and involving the state. That's where transparency is coming in. That certain kinds of arbitrations, because it involves public interest, public money, it has to be transparent. That's why you can see, if you are seeing an ITSIC proceeding, you can watch it live as the arbitration is going on. The award has some precedent value. In arbitration, awards have no precedent value. In terms of you, I mean, you can this one, but you never quote an arbitration award in a commercial case and say that this I follow this. But in investment arbitration, people do deal with issues like what is investment, expropriation, and all these things. So I think that is the reason. But I see one thing that is happening now. Many institutions want to show that their process is very, very transparent, not transparent, that they have good quality, good quality. You know, they want to, I mean, it's become part of the badge that we have good quality arbitrators, good quality award, and this is the standard, and we want to publish it. So what they do is redacted. ICC has started that. Singapore is looking at it. Everybody is doing it. So I think now, basically, if you want to get an award, you can get quite easily, because once it goes to court, in my country at least, it becomes public record. So you will see the award. Thank you.
You're right. I mean, ICC allow for redacted arbitral award. Maybe. Yes.
السلام عليكم. سؤالي للأستاذ سموأل. في مسألة أنت في بنك سحار وعندنا بنك سحار الإسلامي. اليوم المالية الإسلامية في السلطنة أصبحت كبيرة، تقريبا 20% تحوز. اليوم في العقود عندكم، هل تضمنوا العقود شرط للتحكيم؟ هذه مسألة هامة. وسؤال آخر، أنت كونك رئيس دائرة الشؤون القانونية، برأيك ما هي الوسيلة الملائمة أكثر لتسوية نزاعات الصيرفة الإسلامية؟ هل هي المحاكم أم التحكيم؟ شكرا.
شكرا جزيلا على السؤال. لعلي تطرقت يعني خلال الحديث لماما لموضوع الصيرفة الإسلامية، لما ذكرت إنه التحكيم هو خيار أنسب لما يكون في تعقيدات في الاستراكشر في الهيكلة. المعاملات الإسلامية والصيغة الإسلامية يعني بالذات المستخدمة في البنوك بشكل كبير هي صيغ الصيغ بدعتها شوية فيها تعقيد ما كل الناس بيفهموها، وبالتالي أعتقد إنه هي بطبيعتها أنسب، يعني هي موضوع أنسب للتحكيم منه إلى المحاكم. وطبعا توجد هيئات تحكيم في المنطقة حوالينا متخصصة في هذا النوع من النزاعات. فأنا في تقديري إنه إذا كانت الشروط الأخرى مستوفاة اللي هي المتعلقة بحجم المعاملة، لأنه أنت ما عايز، يعني أنت في النهاية لما نحن ناخذ قرار إنه نروح إلى التحكيم أو إلى المحكمة في اعتبارات تجارية لازم نخليها في حسابنا. ما بنكون عايزين ندفع مثلا أتعاب للمحكمين وللمحامين تفوق قيمة الدعوة وقريبة من قيمة الدعوة ولا كذا. أوكي؟ فإذا توفرت الشروط الأخرى أنا أعتقد إنه المعاملات الصيرفة الإسلامية هي أنسب إلى التحكيم منها إلى المحاكم. أما بالنسبة للبنك فيعني ينطبق عليه نفس الكلام اللي أنا تفضلت فيه، إنه نحن ندرس الموضوع بشكل كامل ونشوف إيش هي المؤشرات الموجودة. هل مبلغ الدعوة يعني قيمة المطالبة كبيرة؟ هل الاستراكشر معقد؟ هل نحتاج إلى خبرة نوعية ما متوفرة في المحاكم أو كذا وكذا؟ ومن ثم نقرر يعني. شكرا جزيلا، أتمنى أكون جاوبت.
بس يا رجال الله يعطيك العافيه.
ماشي. ثانك يو دكتور فهد and the speakers for their valuable input. Allow me just to speak in Arabic for easy reference to our colleagues here. I heard from you and from a previous speaker that bad settlement is better than good arbitral award. أنا بعتقد هذا المثال مع كل الاحترام والتقدير هو إلى حد ما مضلل، وهو يحمل رسالة سيئة باتجاه التحكيم. وأنا أختلف معك تماما بتفسير هذه العبارة بهذا التفسير، لأن الذهاب إلى التسوية أحيانا لا علاقة له بالتحكيم، وإنما له علاقة.
بس أنا صح، إحنا
أيوة.
ما كان تعليق عليها، يمكن نستشهد بها سابقا بس ولا
لا صحيح. بس دكتور لو سمحت، لأنه هاي كلام إنه قيل أكثر من مرة، إنه لأنه السيتلمنت وإحنا كنا بنشتغل السيتلمنت أحيانا الطرف بروح للسيتلمنت ولا التسوية، مش لأنه بيكره التحكيم، قد يكون لأنه مضطر بحاجة لشوية كاش باخذ شوية تسوية مشان يمشي شغله. لو كان معه كاش بجوز ما يروح على التسوية ولا يرضى في التسوية. هذا واحد. اثنين، في العقود المالية والعقود الإنشائية أيضا الزميل الفاضل إدريس كان متحفظا كثيرا إلى حد ما في حديثه عندما كان يتحدث عن التحكيم، علما أنه أصلا التحكيم عندما خلق أو وجد في العالم كله، وجد في المنازعات المالية والإنشائية ليس فقط للمزايا الإجرائية اللي بيتعلق فيها التحكيم، وإنما للمزايا الموضوعية. لأنه أنا اليوم دكتور وإنت قانوني، صحيح إحنا قانونيين بس إحنا مع خبرة طويلة لمدة 30 سنة لما تشتغل بالتحكيم بعقود الإنشاءات تنظر إلى النزاع التحكيمي في عقود الإنشاءات بطريقة مختلفة وبطريقة متعمقة تجمع ما بين خبرتك القانونية وخبرتك الهندسية اللي بتصير مكتسبة مع مرور الزمن. القاضي اليوم، القاضي الوطني في كل دولنا عنده 10 قضايا على الأقل كل يوم، ال10 قضايا بمواضيع مختلفة، مش فاضي يتخصص ليك، بروح برمي القضية على الخبير وبقول لك روح اكتب لي تقرير خبرة، وتجد أن الحكم بالنتيجة على الأقل من ناحية الوقائع ومن ناحية النتائج الواقعية اللي توصل لها هي كل ما قاله الخبير. بينما في التحكيم وزي ما حكى الدكتور راجو، احنا بالتحكيم لما نشتغل بننفذ تقرير الخبرة التنفيذ وبننفذ الخبير التنفيذ في الكروس اكزامينيشن، عرفت عليه، وبالتالي ممكن ناخذ في تقريره وممكن نرد تقريره وممكن ناخذ فيه جزئيا. هذه الخصوصيات اللي بيكتسبها التحكيم مع مرور الزمن من خلال خبراء متخصصين في جوانب مختلفة، القانوني مع الهندسي مع المالي، هي اللي بتجعل التحكيم خيار أفضل. لكن ان تنظر دكتور وانت سبحان الله يعني تفكيرك بنكي، تفكيرك مالي يعني لانك في البنك خايف على قروش تدفع. اليوم اذا بتتكلم كوست دكتور من حيث الكوست في التحكيم، ما تحسب لي فقط القروش اللي بتدفع للمحكم بتدفع من المحامي، احسب قيمه الوقت. انا عندي قضيه بالاردن، بتكلم هيك بالاردن، انا عندي قضيه مقاولات في الاردن قعدت 15 سنه لما طلع فيها قرار قطعي. انت ال 15 سنه قديش 9% فائده سنويه، احسبها في ال 15 سنه بالاضافه الى، فلذلك انا التحفظي كان على كلام الدكتور سمو، لانه هو نحى منحى مختلف عن التحكيم. مع الشكر
دكتور على المداخله القيمه. انا بس باكد انه الجلسه لم تقل انه قلت لا هو يستشير بها ولكن لا يؤكدها.
اسمح لي بس
وكذلك ذكرنا، لا بس معليش اسمح لي، ذكرنا انه لا نؤيد الراي هذا. اعتقد عشان اكون منصف للاخ سمو، هو قال في مداخلته انه من الاحرى هو تقييم الموقف وتحديد الموقف واختيار الحل الافضل. ليس بالضروره انا في التحكيم وانت في التحكيم. اذا هو يحرص على البنك وماله، كذلك لا نكون احنا نحرص على التحكيم من جهتنا. هو يقول أنا تقييم الموقف حسب الحاله، حسب ما لدي من استشهادات، ما لدي من وقائع، ما لدي من evidence، اقيم وضعي. قد يؤول الموضوع الى تحكيم او غير تحكيم، هذا امر.
صحيح. شكرا جزيلا دكتور، شكرا جزيلا على السؤالين، واسمح لي ارد عليك في دقيقه واحده. الشيء الاول بالنسبه للكلام اللي انا نقلته عن سابق في ندوه سابقه، انا بانه باد سيتلمنت، انه في حد قال له انه باد سيتلمنت از بيتر ذان اجود اوكي. انا ذكرت تحديدا انه I am with the settlements so long as they make commercial sense. اوكي، واعتقد الكلام كان واضح يعني. اوكي، الشيء الاخر عن موضوع الكوست، استاذي العزيز، انا ما يعني ما ابني قراري فقط على عنصر واحد. في عده عناصر موجوده، نقيم كل العناصر اللي موجوده وبناء عليها نبني القرار. الكوست واحد من هذه العناصر، وانا اتشرف ان اكون في القطاع المصرفي والقطاع البنكي. شكرا.
اوكي، شكرا جزيلا. Thank you again. A round of applause for our esteemed panelists for a great event, great session. Thank you very much.
نشكر متحدثين الجلسة الرابعة. والآن مع الجلسة الخامسة، والتي سوف يناقش ضيوفنا فيها حول نزاعات التحكيم في عقود الحكومات مع المستثمرين الأجانب. تركز هذه الجلسة على دور التحكيم في تسوية النزاعات المتعلقة بالعقود الحكومية، مع إبراز الأطر التنظيمية وعمليات الموافقة والتوازن بين حماية المصالح العامة وضمان ثقة المستثمرين. ويقدم التحكيم بديلاً أكثر حيادية وكفاءة ومرونة مقارنة بالتقاضي التقليدي. تدير هذه الجلسة الفاضلة سارة مالك، الرئيس التنفيذي لشركة SOL International، برفقة كل من الفاضلة بسمة الكيومي، شريك ورئيس قسم تسوية المنازعات في شركة التميمي وشركائه، والفاضلة روادنا الطيار، المؤسس والشريك الإداري لشركة تسوية، والدكتورة لوانا كنول من شركة أدلشو جوار. فليتفضلوا مشكورين.
Hang on, have you told them? We've decided with it. Awana, have you got one of these? Because you might need it. We do some Arabic. Have you got one of these? Oh, no, I don't. Ask someone to get it to you. Yeah. I'll get some. Hello. Good afternoon, ladies and gentlemen. Firstly, I'm going to ask all of you who are at the back to please come forward. I can't see you from here, and I don't know if you hear me properly, but we'd like you to be involved, so please do come forward if you may. Secondly, we are going to, for your benefit, do this panel in both English and Arabic. So hopefully you'll be able to follow. And there are translation sets outside for those of you who need them. Could we get one on the stage, please? Could somebody get me, one of the organizers, get me a translation for Iwana on the stage, please? Thank you. Before I start this panel, can I have a show of hands from people who've ever been involved with government arbitration? If you have, please put your hand up. Okay, so there's few. Okay. This panel is pitched for all your benefits, so those who know about government arbitration or contracts with government and those who don't. And before I start, I'd like to obviously introduce our wonderful panelists, and I think I'm allowed to say that I got the best panel of today. We have Miss Rozana Altaya, who's in the middle. Rozana's from Saudi Arabia, and she's the founder and managing director of Taswiya. She's an independent arbitrator and mediator with over a decade of experience of handling complex high-value disputes in multiple sectors. She serves on the ICC court. She chairs the ICC Arbitration and ADR Committee in the Kingdom of Saudi Arabia. And she sits on panels at the SCCA and ADGM. She holds an LLM in International Dispute Resolution from Queen Mary. Thank you, Rozana, for joining us today. On her far right, we have Miss Iwana Noltuda, a partner at Adelshaw Goddard and a member of the International Arbitration Practice who's flown in from Paris. She's a leading practitioner in international arbitration with 15 years of experience as counsel and arbitrator in complex commercial investment dispute, energy, construction, competition, and distribution. She's recognized by the Legal 500 as a formidable opponent and a next-generation partner, and she regularly appears before major arbitral institutions, including ICC, ICSID, VIAC, and regional fora. And the first Romanian arbitrator who was appointed to an ICSID tribunal. Congratulations to you. In addition to her practice, she plays an active role in shaping the field through her work on the ICC Court of Arbitration, and she's on the board of the SCC Arbitration Institute, qualified in France and Spain and instrumental in developing arbitration communities across Europe. Thank you for joining us today. And finally, last but not least, Basma Mubarak Al-Kayumi, a local, homegrown. Basma is a partner and head of dispute resolution at Al-Tamimi, one of our sponsors, thank you, with over 18 years of experience handling complex high-value disputes. And she serves as a member of the ICC Court of Arbitration, both as counsel and arbitrator in significant local and international matters. Prior to joining Al-Tamimi, she founded and led BK Law, where she has a strong professional reputation. So, ladies and gentlemen, today we're going to discuss with you what happens when we have contracts with governments and how that affects foreign investors, do's, don'ts, and what the practical kind of guidelines are. And on that note, I'm going to hand to you, Basma, because I think what would be useful is for you, some of you may not understand the intricacies of what is a government contract, who are states, what are we talking about when we're delving into this issue. So Basma, could you please shed some light for us? Thank you.
Thank you so much, Sarah. مساء الخير جميعا، يسعدني ويشرفني أن أكون معكم هنا اليوم. سوف أتحدث باللغة العربية، وأعتقد هذه فرصة أيضا لاختبار قدرات المترجمين لا شك فيها حتما، وأيضا حتى يعني يكون من السهولة على الجميع متابعة محاور هذه الجلسة. حديثي سوف يرتكز على تناول المبادئ الأساسية التي تشكل الإطار الفكري والقانوني للنزاعات ما بين الدول وما بين المستثمرين الأجانب. تحديداً سوف أتناول 7 محاور. المحور الأول هو الفرق ما بين التحكيم التجاري والتحكيم الاستثماري. التحكيم التجاري هو الذي قد تكون أيضاً أحد أطرافه يعني جهة حكومية، إحدى الجهات الحكومية أو شركة مملوكة للدولة، والطرف الآخر مستثمر، لكن منشأ العلاقة هو عبارة عن عقد تجاري صرف، قد يكون عقد مقاولات على سبيل المثال أو عقد مشتريات أو غيرها. وهنا تكون الدولة تمارس دورها كأي طرف في تعاقد تجاري، متعاقد تجاري مثلها مثل أي طرف آخر، فتعامل مع المستثمر يعني بهذه الناحية. طبعا يتفق الطرفان على في هذا الإطار على إخضاع العقد لشرط التحكيم، وهنا هذا يشكل بمثابة تنازل من الدولة عن مبدأ الحصانة في الولاية القضائية، فهي تتنازل وتقبل خضوعها للتحكيم وهذا هو التحكيم التجاري. فهيئة التحكيم عندما تنظر لهذا التحكيم تنظر غالبا لنزاعات تتعلق بتنفيذ العقد، سواء بحسب طبيعة العقد. فلنفترض أنه عقد مقاولات، قد نكون أمام مثلا نزاع حول أوامر تغييرية أو حول السداد أو غيرها من البنود وتنفيذ العقد. أما التحكيم الاستثماري فهو التحكيم الذي يكون منشأه أطرافه تكون الدولة، والطرف الآخر يكون المستثمر الأجنبي، ومنشأه لا يكون عقد وإنما اتفاقية استثمار. قد تكون اتفاقية استثمار ثنائية، أو مثلا اتفاقية التجارة، معاهدة استثمار، أو اتفاقية تجارة حرة أو غيرها. فإذا مردها هو التزام الدولة في هذه الاتفاقية، وغالبا النزاع لا يتمحور حول يعني مدى التزام الدولة ببنود عقد معين، وإنما حول مدى التزامها بالمعايير الدولية التي التزمت بها في تلك الاتفاقية. فهذا هو الاختلاف والفرق ما بين التحكيم الاستثماري والتحكيم التجاري. أعتقد أنه جزء أساسي توضيح هذا الفرق. وهنا المستثمر ماذا يعني يهتم، أو ما هي المطالبات التي قد تتمحور حولها يعني دعواه؟ المعاملة العادلة والمنصفة، عدم التمييز، على سبيل المثال أيضا حماية التوقعات المشروعة لهذا المستثمر. فهنا الدولة كسلطة يعني ينظر لها كسلطة عامة، والتحكيم يخضع سلوك الدولة كسلطة عامة للفحص. المحور الثاني الذي أود أن أتحدث عنه هو حدود مسؤولية الدولة والتمييز بين أعمالها التجارية وبين أعمالها السيادية. فالدولة عندما تكون طرف في التحكيم هي طرف يعني ذو طبيعة مميزة نوعا ما. لماذا؟ لأنه الدولة لها هي سلطة سيادية، وبالتالي تمارس هذا الدور من خلال مثلا أعمال التشريع، فرض الضرائب، إنفاذ القانون، وغيرها من الأمور التي تختص بها كسلطة. لكن أيضا قد تكون الدولة تدخل في هذا التحكيم كمتعاقد، وبالتالي أعمالها التجارية عندما مثلا تبرم اتفاق لعقد مقاولات أو لعقد مشتريات أو غيرها، فهنا العمل الذي تمارسه الدولة مختلف، وبالتالي تتحدد يعني من المهم جدا التمييز بين هذين الوجهين للدولة. لماذا؟ حتى نحدد أولا هل التصرف هذا قابل لإخضاعه للتحكيم أم لا، لأنه الأعمال السيادية مثلا فرض الضرائب، التشريع أو غيرها قد لا يكون خاضع للتحكيم. وأيضا مدى إمكانية أن تعتمد الدولة وتستند على مبدأ الحصانة، وأيضا احتمالات التنفيذ. يعني عندما نحلل ما مدى إمكانية تنفيذ هذا الحكم، ما هي الإشكالات التي قد تواجهها، من الضروري أن نرجع مرة أخرى لهنا الدولة بأي وجه كانت في هذه العلاقة. المحور الثالث أيضا أهمية تحديد مقر التحكيم عند صياغة بند التحكيم أو شرط التحكيم. وهنا الاختيار ليس جغرافي، وإنما هو قرار يعني قانوني يجب أن يؤخذ بحذر شديد. لماذا؟ لأن مقر التحكيم يحدد القانون الإجرائي الذي سوف ينطبق على إجراءات التحكيم. سيحدد أيضا السلطة القضائية التي بإمكانها أن هي تنظر دعاوى البطلان أو أي إجراءات أخرى أثناء سير الدعوى التحكيمية. بالإضافة إلى ذلك أيضا ما هي الحالات التي يمكن أن يحكم فيها ببطلان حكم التحكيم. فاختيار المقر يعني مسألة قانونية جوهرية صرفة وفي غاية الأهمية. أيضا بالنسبة للمستثمر الأجنبي عندما ينظر لهذا البند، المستثمر الأجنبي بالنسبة له هذا هو عبارة عن يعني جانب من جوانب المخاطرة التي يجب أن يعني يديرها بشكل جيد. بالنسبة للدولة هي مسألة سيادة أيضا، يعني ما هو المقر الذي سوف تقبل أن يتم التحكيم فيه. فهذا هو الفرق يعني وأهمية مقر التحكيم. المحور الرابع العلاقة ما بين القانون الوطني وما بين قواعد النظام العام. نحن استمعنا ربما كثيرا في الجلسات السابقة عن مصطلح النظام العام. حتى عندما تكون الدولة طرف في هذا في إجراءات التحكيم، فحتى وإن اتفق الأطراف على قانون أجنبي يحكم العلاقة فيما بينهم، لكن تظل مسألة النظام العام يعني ذات علاقة وذات أهمية. إذا ما كانت أثناء نظر الدعوة التحكيمية فهي حتما في أثناء إجراءات التنفيذ. لذلك عندما ينظر إلى أو تدرس الإشكالات والاحتمالات التي ممكن أن يعني تكون ذات أهمية في مسألة التنفيذ، لابد من لا نكتفي فقط بتقييم شرط التحكيم والاتفاق التعاقدي ما بين الطرفين، وإنما النظر إلى متطلبات وقواعد وماذا يقصد بالنظام العام. المحور الخامس إشكاليات تنفيذ الأحكام ضد الدولة، موضوع الحصانة. فربما هذا الجزء هو الأكثر حساسية والأكثر يعني إثارة للجدل في هذا الجانب. لماذا؟ لأنه مثل ما ذكرنا الدولة تتمتع أولا بنوعين من الحصانة، حصانة من الولاية القضائية وهذا تكلمنا عنها، والدولة عندما توافق على الدخول في شرط تحكيم فهي تتنازل عن مسألة هذه أو عن هذا الشكل من أشكال الحصانة، لكن هذا لا يعني أنه تلقائيا هنالك تنازل عن الحصانة فيما يتعلق بالتنفيذ، لأنه هنالك يعني بعض الأصول والممتلكات التي تملكها الدولة لا يجوز ولا يصح قانونا أن تخضع لإجراءات التنفيذ. على سبيل المثال مثلا البعثات الدبلوماسية، الأصول يعني التابعة للبعثات الدبلوماسية، الممتلكات العسكرية تلك المخصصة للمنفعة العامة، فبالتالي عند الدخول في إجراءات التنفيذ لابد من يعني إدراك ما هي الأصول التي يمكن أن يتم التنفيذ عليها وما هي الأصول التي لا يمكن أن يتم التنفيذ عليها، وهذا جزء أيضا في غاية الأهمية يجب أن يؤخذ في عين الاعتبار من قبل المستثمر الأجنبي عند دراسة مسألة التنفيذ. المحور السادس أهمية الدور المتزايد لاتفاقيات الاستثمار ومعاهدات الاستثمار الثنائية. في كثير من الأحيان تبرم اتفاقيات ما بين الدولة ما بين يعني دولتين مثلا أو أكثر على أساس يكون هنالك منظومة معينة لحماية الاستثمار وحماية المستثمرين بين الدول هذه. هذه تمكن المستثمر الأجنبي أولا من الحصول على حد أدنى من المعاملة الاستثمارية في الدولة التي سوف يعني تستقبل هذا الاستثمار، وأيضا حقه في اللجوء مباشرة للتحكيم، وهذه ميزة يعني هو يعتمد طبعا على بنود الاتفاقية أو المعاهدة، ولكن بدل ما يلجأ للمنظومة القضائية الوطنية هو ممكن أن يلجأ للتحكيم ويعني يواجه الدولة إذا أخلت بأحد بنود المعاهدة تلك في إطار التحكيم الاستثماري الدولي. وهذه يعني ميزة بالنسبة للمستثمر تعطيه الكثير من الطمأنينة، لأن هنالك شيء من إمكانية التنبؤ بالإجراءات بسير العملية، وأيضا هنالك يعني مؤسسات دولية مثل أكسد على سبيل المثال التي تتولى مسألة التحكيم الاستثماري. النقطة الأخيرة التي أود أن نتحدث عنها هو أهمية فهم ضرورة تحقيق التوازن ما بين مصالح الدولة وما بين مصالح المستثمر الأجنبي. لماذا؟ الدولة في النهاية يعني هنالك مصالح حقيقية ومهمة لابد أن ترعاها الدولة وتحرص عليها، وهي تفعل ذلك عند دخولها في أي علاقة سواء كانت تعاقدية أو في معاهدة استثمار مثلا، وهي أولا أن هي حماية سيادتها، تنظيم الاقتصاد، الحفاظ على الخدمات العامة، حماية الأموال العامة. ففي معايير أساسية النظام العام لا يمكن يعني غض النظر عنها أو غض الطرف عنها. بالنسبة للمستثمر هو يبحث عن حماية حقوقه كمستثمر، أن يكون هذا الاستثمار طويل الأمد لا يكون قصير أو يعني قابل للإلغاء أو المخاطرة، وأيضا أن يكون هنالك شيء من الاستقرار والمعاملة بدون تمييز أو غيرها. فهذه هي المصالح على يعني في طرفي المعادلة التي نحن بحاجة إلى أخذها بعين الاعتبار ومحاولة الوصول إلى معادلة حتى يكتسب التحكيم أيضا مصداقية، لأنه هيئة التحكيم عندما تنظر يجب أن تراعي المصالح من هاتين الجهتين ومصالح الطرفين بنفس الطريقة. هذه هي الجوانب الأساسية والمحاور الأساسية التي وددت أن أتحدث عنها كمقدمة فيما يتعلق بالتحكيم وفض النزاعات بين الدول وما بين المستثمرين الأجانب.
Thank you very much for a very thorough overview of the topic area. And I'm going to turn to you and rewind it back a bit. Our title is Arbitration Disputes in Government Contracts. Who is the government? What is the government? And who is the party to these disputes? We know privity of contract. We know it's always supposed to be the two parties. And obviously we've elected into having arbitration outside of the judicial system. So what do we understand in this landscape? Who are the parties and who's the government?
Hello, everybody. It's an absolute pleasure to be here in this stellar panel. So I think when we prepared the panel, we thought part of the introduction should also be who is a state entity and what exactly do we understand by state entity. So I'm building up on what Basma was saying. So, of course, the states may sign contracts through ministries or agencies of the state or special purpose companies that they create for this purpose, or legal or formal entities which are under its control. But what I thought was interesting is to say that sometimes the party or the state entity or the ministry who signs the contract is not necessarily the one who is actually benefiting from the contract. So I wanted to just say that when we start an arbitration against the state or a state entity, we always have to look also to whether the signatory, which is the rule, usually you would go against the signatory, whether the signatory itself is the one who is the beneficiary of the contract. And sometimes, because domestic laws are actually requiring a certain entity to sign the contract, the reality is that once the contract is actually executed, you realize that the entity who benefits from that contract is a different one. So we have to pay attention to that. Also, an important point is that sometimes in government or state contract with state entities, sometimes you have in the contract, in order for the contract to be executed, you need the state to do something. You need the state commits within the contract to actually do something for that contract to be executed. And again, in this case, you don't only have as a party to the dispute the signatory, but you also have to look at whether there is another entity or the state itself which committed to an obligation under the contract, and then also add that party or that state to the claimant, to the respondents when you start an arbitration. I think that's an important point to keep in mind.
Thank you very much. Rosanna, I'm going to turn to you for you to give us a Saudi perspective. Now, we know we had the 2024 investment law. I'd like you to give an update on that. It's a fairly new law in terms of what's going on and how that's affecting the Saudi landscape for government contracts and dispute resolution.
Thank you, Sarah. It's a pleasure to be here. Building on what Basma mentioned on investment, Saudi Arabia's new investment law became effective in February 2025, which replaces the foreign investment law and creates a single regime for both Saudi and foreign investors. So it basically focuses on three main areas: simplifying market entry. So previously there was the licensing system for foreign investors, and this has been replaced with a simpler registration model with the Ministry of Investment, intended to speed up the process, establishment, and reduce bureaucracy. The new law also focuses on strengthened protections in terms of, you mentioned equal treatment. So it focuses on equal treatment of Saudi and non-Saudi investors, which is expressly guaranteed, with only a limited negative list of restricted sensitive activities requiring special approvals. I mean, this list is always updated by a special committee, but it's mainly around arms, ammunition, upstream oil and gas exploration, and so on. So investors have the right to free capital repatriation, protection from direct and indirect expropriation, except with fair compensation, and protection of intellectual property and contractual rights. So the law allows investors, and this is a good point, to use alternative dispute resolution, including arbitration, mediation, conciliation, in line with the Saudi arbitration reform, while preserving access to competent courts. The last bit is that the law focused also on expanding incentives for investors by introducing a structured financial and non-financial incentives such as tax breaks, grants, support programs. So this is basically the update on the investment part. I just wanted to say something about the government contracts. The government tenders and procurement law allows government entities to agree to arbitration in contracts typically where the contract value exceeds 100 million riyals. So if there's a state entry, a party to this contract, and the value is 100 million riyals, then they can get approval from the Minister of Finance to proceed with arbitration. Of course, the Saudi, what the Ministry of Finance has is a model clause, which includes the Saudi Center for Commercial Arbitration as the administering center.
Thank you very much. What I do want to focus on with our panel is this state immunity, which is obviously big in the topic we're discussing. So there's perhaps a contradiction, or perhaps there's not a clear nexus between enforcement and the state immunity, especially over kind of state assets. So typically, contracting with the state is obviously different from contracting with a private, and states will rely on sovereign immunity. Now, that immunity, they'll either follow restrictive immunity, they'll say there's no immunity for commercial acts, but immunity is preserved for sovereign acts, for things like tax and regulation and defense. I'd like your take, please, on what actually happens in practice. How do governments address the tension between enforcing an award and invoking sovereign immunity over state assets? And what practices can be used by all of us to help avoid disputes on enforcement? So both of you, I wonder if you start, and then Basma, if I take your view on that as well, please.
Maybe I start just by saying that there are people who spend years and years on this topic, studying it. So now having a 7 minutes, all together, it's going to request quite an effort of synthesization. Maybe first of all to say that we are speaking about immunity of enforcement, but let's also keep in mind that we also have enforcement for jurisdiction purposes. So basically, this is when immunity for jurisdiction purposes. So this is when the state actually agrees to go into arbitration. It waives its immunity for jurisdiction. And in most of the cases, the fact that a state or a state entity agrees to arbitration doesn't mean automatically that it waives its immunity for enforcement purposes. For a very long time, basically what we understand by immunity for enforcement, the question is, once you have your award, can you go and enforce against the assets of the state? Basically, this is what we are talking about, given that the state has immunity covering its assets. For a very long time, there was this approach, which we call absolute, meaning if it's an asset of the state, you cannot go and enforce against it. Now, this has changed into a more restrictive but not absolute approach, by which the state is immune, but only in those assets which involve the exercise of its sovereign power, not in those assets which are used for commercial purposes. I love case law. Those of you who follow me on LinkedIn know that I publish every week a decision of French courts related to arbitration. So I would like, instead of doing long discussions, I wanted to bring to your attention a very interesting new case in front of English courts, 2025. This is a case, CC Devas versus India. And in this case, the question that was asked to the judge was, did India, by the fact that it signed the New York Convention, did it waive its immunity for enforcement against its assets? In this particular case, CC Devas, the company, wanted to enforce, they had won 2 investment arbitrations, and they wanted to enforce the awards against state assets. Well, the English judge said no. The fact that you signed the New York Convention doesn't mean that you are actually waiving your immunity for enforcement. Waiving immunity for enforcement on state assets has to be express and specific. You cannot infer from the simple fact that the state actually signed the New York Convention. In France, we had a long time ago the understanding that the waiver of the immunity for jurisdiction equaled waiver of the immunity for enforcement. This is not the case anymore. There is actually a law which is quite recent, by which it is very clear that you need a very specific and clear and express waiver of the state in order to enforce against state assets. And there is an interesting case also, I mean, many in France, but one, for example, which also shows the importance of separating the assets which are used by the state for commercial purposes and those used by the state in the exercise of its sovereign powers. And this is a case, it is Comi Simpex case in which the investor was trying to enforce an award in France against the bank account opened by Congo for its UNESCO, for the UNESCO representation, to the Congo's UNESCO representation in France. But that UNESCO representation is a manifestation of the sovereign powers of the state. So the French court said you cannot actually enforce against the state assets which are used for sovereign powers. So to cut it short, in order to enforce against state assets which are used for sovereign, for the sovereign exercise of power, you need an absolute express and special waiver of the state.
Basma, do you want to add to that, please?
Maybe I'll add and explain in Arabic my point, but I think من المهم جدا محاولة إدراك منشأ التوتر ما بين مبدأ الحصانة وما بين أيضا الحاجة لتنفيذ الأحكام التحكيم. يعني هنا الدولة لا تحاول أو لا تسعى في أغلب الأحيان لحماية حقها في التصرف على نحو متعسف أو كيفما شاءت، وإنما هي تحمي مصالح حقيقية يعني باعتبارها سلطة عامة، سواء من حيث مثلا حماية المال العام، الموارد الوطنية أو غيرها. فهنالك يعني مصالح حقيقية جديرة بالحماية. من ناحية أخرى إذا كانت الدولة جادة وراغبة فعلا في اجتذاب الاستثمار الأجنبي، فهي بحاجة إلى أن تؤكد التزامها بأحكام التحكيم وبتنفيذ أحكام التحكيم هذه، سواء صدرت لمصلحتها أو صدرت في مواجهتها. فهو هذا منشأ التوتر ما بين يعني التنفيذ وما بين أيضا التمسك بمبدأ الحصانة. لكن كيف تتعامل الدول مع هذا؟ مثل ما ذكرنا وذكرت أيضا زميلتي، التمييز ما بين الحصانة القضائية، الحصانة من الولاية القضائية والحصانة من التنفيذ. ما دمت أنا كدولة وافقت على التحكيم فتنازلت عن هذا الشكل من أشكال الحصانة، لكن هذا لا يعني أنه تلقائيا تنازلت عن حصانة التنفيذ. فهذه أيضا المسألة اللي تناولتها أيضا زميلتي. من ناحية أخرى التمييز ما بين الأصول اللي ممكن أن ينفذ عليها، وهذه أيضا مستقرة في العرف والقانون الدولي، ما هي الأصول التي يمكن أن يتم التنفيذ عليها والأصول التي لا يمكن التنفيذ عليها، خاصة تلك التي مرتبطة مثل ما ذكرنا بالهيئات الدبلوماسية، بالدفاع، بالمنفعة العامة، المدارس أو غيرها. والمستثمر يجب أن يثبت بأنه الأصول هذه تجارية حتى يمكن التنفيذ عليها. من ناحية أخرى أيضا صياغة بنود العقد بشكل واضح، هذا ضروري لتحديد الحدود والقيود ذات العلاقة. وأيضا استعمال المعاهدات الثنائية، لأن المعاهدات الثنائية هذه تفصل وتشرح سواء فيما يتعلق بحدود الحصانة، فيما يتعلق بالتنفيذ، فيما يتعلق بحقوق المستثمر وغيره. وفي كثير من الأحيان يعني تجنبا لهذا التوتر وحتى لا يصدر حكم مثلا بعد ذلك نتكلم فيه عن الحصانة أو نقدر ننفذ أو ما نقدر ننفذ، كثيرا من الأحيان يلجأ للتسوية ولمحاولة إيجاد حلول دبلوماسية بحيث أنه ما نصل إلى نقطة التوتر تلك. يعني
I'll build on what Basma just said. Her last thing, تسوية, and I think this is what when government entities are involved. Yes. So what government entities prefer, especially in the region, let's look at the region around us. Cultural sensitivities are very important. We need to understand how governments function, and diplomatic relations, negotiation, even mediation is the best option, the best first option before going ahead and escalating any dispute. So
can I just stop you there, because I like to. Does that actually work with government? Do we think it works with government?
Governments prefer to engage diplomatic channels. They prefer to negotiate behind closed doors.
So we don't actually know what's going on, but it's going on.
Region, and I'm talking about the region. In this region, we prefer to negotiate behind closed doors. We prefer to mitigate risks, such as going to, board of grievances, like in Saudi, or going to arbitration. We prefer to figure it out rather than escalate it. It's not easy. I'm not saying it always works. But what I'm saying, we have a responsibility or a duty to have those
Conversations.
this structure in place.
Okay.
Let's negotiate. If it doesn't work, let's engage a third party to mediate. I know some governments are a bit concerned about mediation because of corruption, but I think it's definitely worth it as a first move towards resolving disputes.
I wonder what's your view on that?
Well, I'm a bit less, I'm an optimist by definition,
Yeah.
but I'm a little bit more pessimistic on this one.
So am I.
Because I think civil servants in general do not want to carry the responsibility of settling. In my opinion, and it's sad that it is the way it is, but they would rather go for a bad decision, a word or a decision, and then just have to enforce it. And, it was a decision and we have to comply, other than taking the responsibility of actually having to explain why they accepted those amounts.
Yeah.
But I fully agree that it would be great if people could negotiate more. In my opinion, unfortunately, it's quite rare that we end up with a settlement when the state is involved.
I agree with you. And that's why I said their main fear is they don't want to take the responsibility and their concern of corruption. So it doesn't happen as often as we wish, but I think currently, especially mediation is sort of becoming popular in the region. WTO are discussing mediation among countries, governments, and it's something I think we have a duty to promote that and raise more awareness on it.
So that's what's your view about trying to mediate with government? I think I sit on the side of Iwana here.
I think I am more optimistic. Maybe this is my personal outlook generally, but also from experience. I think, however, the key is timing. When do you approach and initiate mediation? Because if you leave it late, then it becomes you're inviting public opinion on the matter. You're also making it a national pride issue and policy. And so if you do it early on and you choose your timing appropriately, I think the chances of mediation to be successful increase significantly. So the first thing is mediation. The second point that I wanted to comment on is I think you're right. Usually, civil servants don't want to take the responsibility of accepting a settlement that later may seem that was not a very good option. And I think this is true for smaller disputes. But if the dispute is big enough and significant enough, then and also choosing, maybe I'll come back to that later, but they would have the comfort of having a higher authority's endorsement or approval on the mediated settlement. And this would make them more able to take that step. So I think if the dispute is big enough, it's definitely worth considering mediation. And at this point also, it's very important to choose the right access point. At what level I'm going to have this discussion. Because if you're going to have the mediation on a lower level, you're going to face these fears and the fear of accountability and responsibility. But if you approach the right point, the right level, I think the chances of considering mediation and following through with mediation increase also significantly.
I think, Rosanna, what you said is correct, that there's a real kind of momentum towards mediation. We've seen throughout the region laws, domestic laws, international laws that are being applied, and even institutions are taking it on board. The jury's still out for me as to whether it will work. I'm sure it happens behind the scenes, and it's, as you've said, something that governments will be very sensitive to, for people coming to know that they've kind of sat at the table, because sometimes that's seen as, throwing the towel in or saying that it's some kind of fault or blame. That people don't want others to know that they're entering that arena. So it's an interesting kind of position. You'll see even from our panel, we've got different views. Can I just get a show of hands? Do you think with government contracts, mediation would work at the right time behind closed doors? Can I have a show of hands if we think it would? So we don't have as many, and those who say no are the remainders, right? So we're still, people aren't bought in yet, I don't think, to the whole mediation side.
Okay, why? The question is why. We have to always ask ourselves why. Do people understand why? Because, I mean, 2 weeks ago we were here in Oman discussing mediation, and we were saying people always resort to mediation at the end, when it's late in the process, not in the beginning. You mentioned it's better, it's early, but it never happens. I've been mediating for 11 years. People never come at the beginning of the dispute. They always come when things have gone really bad. So
it's a lawyer's fault. It's the lawyers. It's always the lawyers. Okay. I'll keep you there, Rosanna. Just tell us before we turn to the audience for questions. What happens in Saudi? How does the Saudi law approach the enforcement of foreign arbitral awards and disputes? And what challenges do you see that commonly arise for enforcement?
Okay, Saudi has became a party to the New York Convention in 1994. So foreign arbitral awards are enforced in Saudi, of course, subject to the usual public policy and due process filters. But I mean, I'm not going to sit here and say everything is perfect. What I'm saying is Saudi is going through reform. I mean, if you look at the last 3-4 years, we've had a new Saudi companies law. We've had the civil transactions law. We've just recently had the new investment law. So we're going through a lot of reform. We are creating the right infrastructure in order to have a friendly hub for arbitration in the region. So are we there? Maybe not yet, but we've come a long way. SCCA has done an excellent job with advocating for arbitration in Saudi, promoting their SCCA rules. We've come a long way. So we're seeing so much happen. Now, the challenge is, with all the reform that's taking place, what I would say, if you have an arbitral award, a foreign arbitral award to be enforced in Saudi, you really need to work with someone in Saudi or someone familiar with not the theory, but the practice, how things get done. Because with all the changes, you need someone who's keeping up with all of that, revising your contracts, knowing how to enforce an arbitral award in Saudi. This may be the main challenge that you may face because of all the changes that have been happening in the past 3 years.
I think that rings true wherever you are. You need to work with the kind of local jurisdiction because we don't know how it works in practice. There's a law and then there's a reality. Right, because we're girls, we obviously finished before everyone else on time because we can get things done. So you've got extra time for questions. I'm glad to say we're 2 minutes and 24 we still have, which can be your time for questions. So if we have any questions, please raise your hand and the mic will come up. Please introduce yourself. Michael, I see you already. Can someone take the mic to him, please? Thank you. Have one? I think they have one there. Just tell us who the question's addressed to and keep it a short question, please, not long comments. Thanks.
Thank you very much. Michael Patrick Joyce. I'm a barrister, arbitrator and mediator, family home in London, based on a plane usually. I do have a comment. I'll resist making the comment about mediation at enforcement stage. What I really wanted to come back on was when you were talking about what do we do about state immunity. And the we was sort of implicitly lawyers and clients.
Yeah.
Can I turn that question on its head? And what do states do about state immunity? Because there's this trend away from blanket immunity to restricted immunity. And yet the purpose is obviously foreign direct investment. But if the direct investors, the potential investors, don't get the message from the state, then the benefit, or the sort of the bogeyman of state immunity hangs there and acts as a deterrent to the very investment that the state wants. So how do states actually get their message across?
Oana, over to you.
Yes, I wanted to say that we wouldn't speak about state immunity if there would be voluntary enforcement by states. And it's true that the best message that states can send is voluntary enforcement of the award, so that the investors know that in case there is a dispute, they are heard and the award is enforced. So probably this is the best message any state who wants to attract foreign investment can actually send to its investors.
Thank you. A question from the gentleman at the back. Over there.
Thank you very much. My name is Muhammad Amr. I'm the Dean of Faculty of Law, Cairo University. And here I would like to raise, to share a comment and raise a question. The comment is that the governments must believe that the contracts with investors and BITs is the best way for them to improve the investment environment. It is not the right approach is that we get in dispute with the investor and then we go to the process of arbitration or mediation and then fail to enforce the award. So this is very important, and this is the message should be sent to all governments, especially in our region, that investment treaties, BITs, is the way to improve the development and so on. My question also to Basma. Basma, you have raised the issue of commercial arbitration and investment arbitration. The main issue that we face sometimes between the two procedures, the commercial and investment arbitration, is there is judicata or حجية الأمر المقضي, which is when we refer the dispute to investment arbitral tribunal, they decide not to issue an award because of jurisdiction problems or so, and then the investor would like to go to commercial arbitration. To what extent the commercial arbitration tribunal is bound by what have been decided by the investment arbitration tribunal?
Thank you for the question. I think once the matter is referred to commercial arbitration, they would have the arbitral tribunal would have the ability and the scope to revisit these topics and decide on the matter.
Well, especially if the investment arbitration tribunal consider itself not competent and there is a jurisdictional issue there, then there is no res judicata per se because there was a jurisdictional issue.
Maybe we'll take one last question from anybody and then we'll wrap up. Any more questions? No. Okay. Oh, sorry. There's a question here at the front. The microphone.
هو حقيقة I'm going to speak in Arabic. هو أكثر يعني مداخلة للمتحدثات لضبط الإجراء البروسيس. التسوية في الأمر العملي والواقعي على الأقل اللي أنا أعرفه في منازعات النفط والغاز، أغلب المنازعات تحل بالتسوية. وإذا ساعدتني الذاكرة أتذكر إحصائية عن طريق الICC حوالي 50 قضية في الأويل أند غاز، ما المتوقع بما إنه منطقة الخليج والمنطقة المينا ريجن إن جنرال تنتج ما يعادل تقريبا 50% من إنتاج العالم والمخزون تقريبا في هذا الحصص أو في هذا الحدود، فالمتوقع أنه يكون 50% تكون منازعات. اللي اتضح حسب هذه الإحصائية أنه المنازعات لا تزيد عن 3%. هذا يؤكد أنه أغلب التسويات في منازعات النفط والغاز تحل بالتسوية. الآن نحط النفط والغاز على جانب. الآن الإشكالية العملية عندنا في اعتقادي هي موضوع الإجراءات اللي تنظم سلطة الموظف الحكومي في إقرار التسوية وحمايته من تبعات الجهات الرقابية أو الرقابة الشعبية والإعلامية وخلافه. أريد الآن من المتحدثات يا ريت إذا في تجارب مثلا في فرنسا أو في المحيط الأوروبي بحكم خبرتكم يعني، والأخوات طبعا في السعودية والأستاذة بسمة، إذا عندكم أمثلة تساعد في كيفية تنظيم موضوع ضبط الجوانب الإجرائية للتسويات، لأنه مثل ما قلنا يمكن في الجلسة اللي قبل هذه أنه كثير من الموظفين الحكوميين لا يرغبون في الدخول في التسويات مخافة التبعات. شكرا. بالمناسبة أنا من الناس اللي يؤمنوا أن التسوية هي الحل يعني، ورفعت يدي، بس نريد نستفيد من تجاربكم يعني. شكرا.
Do we have any examples that we can share in respect to that?
No, but I think it's very difficult to know, because this is, as we were saying, done between closed doors.
Yeah.
So I think it's difficult to let's say to analyze a couple of cases and draw some conclusions out of this. So unfortunately, I think it's extremely opaque and very difficult to know and transparent in that sense.
But you make a good point that a lot of this, I mean, most of these disputes we never get to know about them, or we don't know they've been filed, and that's because they may well be resolved behind closed doors, but they actually remain behind closed doors. With that, we're going to wrap up. I'd like you to join me in thanking our stellar panel for all their insights. Please join me in the traditional way. Thank you.
حضورنا الكريم، يسر مركز عمان للتحكيم التجاري دعوتكم جميعا بحضور وجبة العشاء اليوم في مطعم روزنا في مرتفعات المطار في تمام الساعة 7:30 مساء. قبل جلستنا الختامية نشكر متحدثات الجلسة الخامسة لهذا اليوم، وننتقل الآن إلى الجلسة السادسة والختامية لهذا اليوم، والتي سوف تتحدث عن التكنولوجيا في التحكيم والوساطة، الفرص والابتكار والتحديات الأخلاقية. وتستعرض هذه الجلسة القضايا الأخلاقية المرتبطة باستخدام الذكاء الاصطناعي والتكنولوجيا في التحكيم والوساطة، بدءاً من مسائل السرية والتحيز وصولاً إلى الشفافية والمساءلة والتعامل مع القرارات التعسفية ضمن إجراءات التحكيم. يدير الجلسة الفاضل ناصر الحبسي، شريك في شركة أدل برفقة كل من الفاضل عيسى بن عبد الكريم الغساني، نائب رئيس مجلس إدارة مركز عمان للتحكيم التجاري، والدكتور رياض فخري، مدير مركز دراسات الأعمال في جامعة الحسن الأول بالمغرب، الفاضلة أناستا دولوسكا، محامية أولى في تسوية المنازعات في شركة بار أند كير، الفاضل ليونود، محامي ومستشار قانوني في 5 جامبيت ديسبيوتس. متمنين لكم متابعة ثرية.
دكتور رياض فخري. دكتور رياض فخري، أعتقد شفته أنا هنا متواجد. نعم. عموما السلام عليكم جميعا. Good afternoon, everyone. Welcome to our panel on AI in arbitration and mediation. It is an honor to moderate this distinguished panel, bringing together some of respected experts in arbitration, mediation, and legal innovation. Our topic is exciting, and actually we meant to have 5 speakers, but we are missing one. Hopefully he will join us shortly. So AI is the hot topic where every legal conference we see panel who speaks about the AI. But today we have very well respected speakers who will speak about AI in different way. I know we are the last panel, so everyone is tired, including myself. So I will let my assistant to help me in moderating this panel. So let me introduce my assistant, who is Mr. ChatGPT. So I will let Mr. ChatGPT to introduce my speaker in a brief. So I'll save some of the energy to the last. Hi, Mr. ChatGPT. I'm moderating my last panel. Can you help me to introduce my speaker, starting with Ms. Anastasia, and then Mr. Leon. After that, Mr. Sheikh Isa, and then Dr. Fakhri. Please proceed.
Of course, Mr. AI is on it. Let's do those intros in style. Let me start by introducing our first speaker, Ms. Anastasia Dilska. Anastasia is a senior associate at Care, and she's been recognized as a Lexology future leader. With over 40 complex arbitrations under her belt globally, she brings a wealth.
Excuse me, do it slowly and clearly.
Absolutely, I'll slow it down and make it nice and clear. Let me start by introducing our first speaker, Miss Anastasia Dilska. Anastasia is a senior associate at Care, recognized as a Lexology future leader. With more than 40 complex arbitrations globally, she brings a wealth of experience and insight. Next, we have Mr. Leonid Shmatenko, a leading counsel in international arbitration, recognized by Lexology and Legal 500. He's also a lecturer, author, and a judge of the Swiss Sports Tribunal. Then we have Sheikh Isa Al-Ghassani, deputy chairman of the Oman Arbitration Center. He's a distinguished lawyer, arbitrator, and a key figure in shaping arbitration in Oman. And finally, Professor Riyad Fakhri, one of the region's most influential academics in arbitration and mediation, a prolific author, and a long-standing expert across the MENA region and internationally. Thank you all for being with us today. I hope that pace is perfect for you.
Well, our topic is about AI, so I thought it will be a good idea to let Mr. ChatGPT be here today. So we have our 4 speakers. Ms. Anastasia, ChatGPT already introduced you, so I hope he covered that. And then we have Mr. Leon and Sheikh Isa and Professor Dr. Mr. Fakhri. So I would like to start with my first question, and if I may, I will address this question to the audience. If you are in favor of using AI in arbitration, especially in drafting the arbitration award, just I want you to raise your hand if it's who says yes. Just we have one person. Dr. Professor Riyad Fakhri, هل أنت من المشجعين استخدام الذكاء الصناعي في سواء الإجراءات التحكيم أو أي حتى في إعداد حكم التحكيم أو كعمل كأمين سر من أعمال أمين السر في التحكيم؟ فزين شاركنا رأيك في هذا الموضوع.
شكرا جزيلا. شكرا جزيلا سيد الرئيس. أعتقد أنه الجواب يتجاوزني شخصيا، لأنه الذكاء الاصطناعي أصبح أمرا واقعا يفرض نفسه ليس فقط في مجال التحكيم وقطاع التحكيم، وإنما في قطاعات أخرى كثيرة. شخصيا طبعا لا أستطيع إلا القول إلا أنه نعم وأؤيد بشدة استخدام الذكاء الاصطناعي باعتباره نعمة من النعم التي أنعم الله علينا من خلال العقل البشري. لكن طبعا يجب أن يحاط أو يؤطر بمجموعة من الضوابط القانونية والأخلاقية التي تسمح بضمان العدالة والنزاهة في العملية التحكيمية. لماذا أؤيد استخدام الذكاء الاصطناعي؟ لأنه بكل بساطة يقدم إمكانيات كبيرة لمستوى من الجودة في العملية التحكيمية كبير جدا، إن كان على مستوى الكفاءة التشغيلية، إن كان على مستوى تحليل البيانات، إن كان على مستوى حتى صناعة القرار التحكيمي في بعض الأجزاء المتكررة منه. لكن طبعا لإمكانية الاستفادة بشكل فعال وناجع من فوائد الذكاء الاصطناعي يجب أن نظل بين نصب أعيننا الضوابط الأخلاقية، والتي قد تصبح فيما بعد قانونية. ضوابط أخلاقية من قبيل الشفافية التي تقتضي بداية الإفصاح، أن يكون أطراف العملية التحكيمية على علم باستخدام الذكاء الاصطناعي، على علم بأي نوع من الذكاء الاصطناعي يستخدم الهيئة التحكيمية، وكذلك على علم بحدود قدرات هذا الذكاء الاصطناعي. هذه الشفافية تقتضي أيضا طبعا أحيانا أن يكون ما يقدمه الذكاء الاصطناعي قابلا للفهم بالنسبة للبشر، وليس على شكل شفرات أو خوارزميات لا يفهمها إلا الذكاء الاصطناعي نفسه. ضمانة أخرى يجب أن تتوفر، أو ضابط آخر، وهو يتعلق بالحياد والنزاهة أو عدم تحيز الذكاء الاصطناعي. اليوم يعاني الذكاء الاصطناعي بسبب العملية التدريبية التي يقوم عليها من الانحياز أحيانا المقصود وأحيانا غير المقصود، فبالتالي يجب أن نعمل مستوى معين من الخوارزميات التي تناسب كل قضية على حدة في مجال التحكيم، تناسب كل نوع من أنواع القضايا على حدة في المسائل التحكيمية. ضابط الثالث مهم جدا، وهو ضابط السرية. اليوم مدعوين إلى البحث عن مستوى أعلى في مجال الأمن السيبراني لكي نضمن عدم تسرب البيانات والأسرار التي نبحث أصلا من خلال التحكيم عن حمايتها. ضابط بالنسبة لي آخر مهم أيضا، وهو المسؤولية ومسؤولية المحكم والهيئة التحكيمية، لأنه لا يجب أن يذهب بنا التفكير ونشطح إلى القول بأن الذكاء الصناعي يمكن أن يحل محل المحكم. المحكم يجب أن يظل هو سيد القرار، هو من يصنع العملية التحكيمية، هو من يصنع القرار التحكيمي، ولكن في نفس الوقت إن استخدم الذكاء الاصطناعي يجب أن يظل متحملا المسؤولية الكاملة كبشر عن الأخطاء التي يمكن أن تحصل، عن الأضرار التي يمكن أن تنجم أحيانا عن استخدام هذا الذكاء الاصطناعي بالنسبة لأي طرف من أطراف التحكيم أو حتى من قبل الغير.
جميل. أشكرك على هذه المعلومات الطيبة. أنا بغيت أشوف إذا أحد من الحضور عنده رأي مخالف أو مؤيد ويحب يشاركنا بهذا في هذا الموضوع. هل أنت من مؤيدي استخدام ال AI في سواء في التحكيم أو في الميديشن أو لا؟ فمن ممكن يشاركنا؟ تفضل. ميكروفون إذا ممكن. الميكروفون للأخ أعتقد موجود في النص.
أول شيء يسعد مساكم، شكرا على هذا المؤتمر الرائع. عبد العزيز الشافعي، باحث دكتوراه في جامعة الحسن الأول. يمكن أنا أكون عكس الناس الآخرين اللي يقولوا إحنا لا نؤيد الذكاء الاصطناعي، بس اليوم أنا قاعد أستخدم ذكاء اصطناعي في أعمال تتعلق بالقانون، يعطيني صياغة جميلة، يعطيني ترتيب أفكار، أنا أغذيه بالمعلومات الصحيحة اللي تكون مناسبة للتخدم، فبالتالي أعتقد أن المستقبل في الذكاء الاصطناعي وليس ضده.
جميل. أستاذ سلطان، إذن في أحد من المخالفين أنه ضد الذكاء الصناعي في مواضيع اللي هي التحكيم، في قضايا التحكيم بشكل عام؟
سلطان الغافري. طبعا أود أن أذكر أنه الذكاء الاصطناعي هو The Coming Wave. أنا قرأت كتاب اسمه The Coming Wave، وهي الموجة القادمة. فالذكاء الاصطناعي هو لا مناص منه. في الأعمال القانونية أتوقع مع المستقبل الذكاء الاصطناعي يساعد حتى الموكلين نفسهم، خاصة إذا أنا أحاسب الموكل بالساعة. حتى الموكلين بتخلص أعمالهم القانونية اللي أنا ممكن إني أنجزه في ساعة، بكون قابل إني أنجزه خلال أقل عن ساعة، في نص ساعة أو في 20 دقيقة. الذكاء الاصطناعي هو الوسيلة القادمة لتجويد وتحسين سواء التحكيم أو الوساطة بشكل أو بآخر، ولكن يجب أن يقنن بشكل أو بآخر. هذا هو رأيي.
نعم. أشكرك أستاذ سلطان. طبعا شخصيا أنا أتفق معك كبروفيسور والأخ سلطان، وكذلك لا أخالفك أخ الكريم، ولكن ال AI يعني على قولتهم شر لا بد منه. فكيفية التعامل مع الذكاء الاصطناعي هذه هي مهمة كل محامي أو كل مسؤول عن هذا البرنامج بشكل عام. الشيخ عيسى، إذا ممكن تفيدنا، كيف ممكن أني أنا أستغل الذكاء الصناعي في مجال التحكيم؟
بسم الله الرحمن الرحيم، مساكم الله بالخير جميعا. دكتور رياض، أعطني حق الاختلاف. يعني أعتقد احنا يعني نمر بمرحلة مفصلية في تاريخ البشرية. أنا بدون تردد وبتحيز مطلق أنا من أنصار الذكاء الاصطناعي. دعوني أضرب لكم مثل. إذا عملنا مقارنة بين الذكاء البشري والاصطناعي، العقل البشري يستطيع أن يعمل من 4 إلى 6 ساعات في حالة يقظة. بعد ذلك تقل القدرات البشرية. هناك دراسات علمية أثبتت عندما يعمل العقل البشري لمدة 17 ساعة يتصرف كأنه تعاطى نسبة 5/10 من الكحول. يصل العقل البشري إلى حالة سكر. هذه حقيقة علمية. فبالتالي لو نقارن بالذكاء الاصطناعي، الذكاء الاصطناعي طبعا أفضل بمراحل كثير. تولستوي أديب روسيا العظيم يقول: المشكلة ليس ما نفكر فيه، المشكلة ما يجري حولنا. الآن العقل البشري يستطيع أن يقرأ من 200 إلى 300 كلمة في 15 دقيقة. أكرر المعادلة: 200 إلى 300 كلمة في 15 دقيقة ويحللها. بينما السؤال المطروح: كم يستطيع الذكاء الاصطناعي أن يقرأ؟ لك أن تتصور من 50,000 كلمة إلى 200,000 كلمة في نفس الوقت. إحنا مقبلين على ثورة فكرية سوف تنقل العالم كما يقال، لأن الذكاء الاصطناعي الآن يتطور بمعدل من 6 أشهر إلى سنة. يكون في نقلات نوعية. ChatGPT-5 الآن. سابقا التقنيات البشرية يعني الاختراعات كانت تأخذ من 60 سنة، ثم 10 سنوات، ثم أقل. أعتقد أي مجتمع بشري لم يفرض على نفسه أن يدخل في عصر الذكاء الاصطناعي ستحدث الفجوة التي لا يمكن تداركها. أتحدث إلى الشباب الذين في سن 30 وأقل. عمان تقريبا مجتمع 60% منهم في سن 30. عليكم أن تدخلوا إلى عالم الذكاء الاصطناعي بأسرع وقت ممكن. على مكاتب المحاماة أن تتبنى استخدام الذكاء الاصطناعي وتستعين بتقنيين ومهنيين. الآن الإحصائيات في أوروبا والولايات المتحدة قد تصل من 30 إلى 50% من المحامين الذين يستخدموا الذكاء الاصطناعي. فيجب ألا نعيش في حالة إنكار وتجاهل الذكاء الاصطناعي. طبعا احنا نتحدث، لو تحدثنا عن التحكيم الآن في بعض العملية التحكيمية من الألف للياء أصبحت تمر عبر الذكاء الاصطناعي. الشخص هو يراقب المتميزون المتمكنون الذين يملكون قدرة في الخوارزميات والتحليل، هم قادرين على التجانس مع الذكاء الاصطناعي. أما فكرة الأخلاقيات والقافلة تسير، سيتحدثوا عن الأخلاقيات، سيتحدثوا عن العدالة، احنا مدعوين بقوة إلى أن ندخل في عالم الذكاء الاصطناعي دون ما تردد على المستوى الفردي. وأنا شخصيا أستخدمه أستشعر الفارق الكبير في تمكين الإنسان في تحليل القدرات. فدعوة للجميع. وأنا أيضا بحضور سعادة الشيخ رئيس المجلس الشيخ خالد، احنا فعلا تبنينا مشروع للذكاء الاصطناعي وسوف يظهر قريبا بإذن الله تعالى، وسيكون المركز قادر على مشاركة الجميع بدون تكلفة. هذا هو ردي وشكرا.
أشكرك الشيخ عيسى. إذا نعقب على الأخير، كنا نحن نشارككم فقط عشان ما تملوا، فأيضا حفاظا على الوقت بنترك مساحة للأسئلة في الختام. أكيد طبعا أثريتنا بهذه المداخلة، ولا شك أنه هنالك مليارات تصرف على الذكاء الاصطناعي. هل تتوقع يوم من الأيام تكون من ضمن اللي هو arbitration clause انه اي نزاع يحال الى التطبيق الفلاني؟ خلينا ننظر بعد 10 سنوات.
اغلبكم على علم بانه الان يوجد سمارت كونتراكتس، يوجد بلوك تشين في تحكيم الان موجود. احنا مقبلون على انه الذكاء الاصطناعي سوف يستلم العمليه التحكيميه من الالف للياء. وايضا المقوله المشهوره انه الارض منبسطه، حتى كل قوانين التحكيم سوف توحد على مستوى العالم. احنا نقبلون على خطوه نتسارع، مثل ما ذكرت لك. ربما تصدر الروايات في 2050 ويتحدث في 2030 عن نهايه العقل البشري. هذا امر متصور
نعم. هو في الحقيقه اللي يقرا تاريخ الاي اي عندما بدا في 1950 لم يستوعبه العقل البشري بإمكانية وجود آلة تفكر بطاقة أكبر من الطاقة البشرية. عموما اليوم الواقع أثبت لنا بأنه ممكن، والمستقبل أكيد سيظهر أكبر مما نراه الآن. Anastasia, if I come to you, how can parties and arbitrator ensure that the use of AI and technology in arbitration and mediation does not compromise the confidentiality? So Mr. Isa is saying that the AI is coming, and for sure that we will use the AI in arbitration. How we can ensure that the confidentiality part of.
Thank you for the question, and thank you to the Oman Commercial Arbitration Center for this panel, for this inaugural event, and congratulations that it's been very successful. And as my task is speak about confidentiality and best practices to ensure that confidentiality is preserved, I also want to thank Dr. Fakhri and Dr. Hassani Mr. Hassani for setting the floor with AI. And a use of AI is no longer a hypothetical. It's not a question whether we will use AI or should we use AI. The reality that it's a reality we wrestle with. We will be using AI, and also huge pressure also from the parties that council and also arbitration centers should use AI. And I also want to come up with some numbers. We already have set the floor with numbers. And in 2025, it was Queen Mary University of London, together with Whitehall Case, conducted international arbitration survey. And 55% of practitioners quoted that they do observe that AI save much time. 44% of respondents quoted cutting costs, and 39% quoted reducing human error. At the same time, 60% of respondents raise concern with confidentiality. Indeed, it is a real issue. Plus 70% of respondents raised an issue with disclosure and transparency. And here lies the main problem with confidentiality and use of AI. It comes a lot with data science and plus with data flows. As many lawyers, we are not, data engineering is not our strongest suit. And we do not really understand quite often what happens with the data once we put this data in AI. We see efficiency, we see quick results, we see that AI can come up with chronologies very quickly, with document analysis, with redrafting of arguments in a clear way to file. But what happens with our data? And here's the main risks with the use of AI. Data is, if you put especially confidential data to OpenAI, to open sources like ChatGPT, we don't know where this data will end up and which servers it will be stored and replicated, and whether our prompts are saved, whether outputs are saved. And this becomes a problem because proceedings are indeed confidential, and confidentiality is one of the backbones of arbitration. And once the confidentiality is undermined, the whole system risks integrity and risks to be jeopardized completely. Plus, we do not want to have more eyes also figuratively speaking, in the proceedings. Because once you use AI, you don't know who else might have access to your confidential data. It might end up on servers in the countries where data protection laws either would be or not on the same level what parties expected when they, for example, provided for arbitration to be in a specific jurisdiction like Switzerland or France or here. Or at the same time, if your data end up in a place where government have a very strong hand and the servers might be seized from one day to another, it's a very real risk, especially for very confidential proceedings with security risks. We are speaking about investment arbitration, or when the confidentiality should really be preserved. And one of the risks is attorney-client privilege. And we are still yet to see what happens if we put confidential information, and if one might argue that attorney-client privilege, which should be distinguished from confidentiality, could be lost and jeopardized. And unfortunately, while we all agree that AI is to be here, the main question is regulation, and arbitration institutions are not really coming up quickly with the regulations. We do see some responses, but they are so far fragmented. For example, at AAA, the American Arbitration Association, the International Center for Dispute Resolution, they come up with general ethics on AI, and they also come up with a duty to disclose use of AI, but this duty is not a hard duty. Same also comes with ICC. They set up a task force on use of AI. No, there is no results yet. And in absence of strict guidance and strict regulations, only two sets of rules are more or less well developed. And I want to refer attention to the Chartered Institute of Arbitration guidelines, which so far presents the most robust AI regulation. But still, when I looked on all of these regulations, the language is very much may disclose, the tribunals may direct parties to disclose, that parties may require tribunal to disclose, but the language is not true. And I think that's the main issue, because parties still want to be in a driving force for arbitration. That's why they resort to arbitration. But given the risks for the whole proceedings, tribunal should also be equipped with certain toolbox what to do with AI and how to preserve the integrity of the proceedings. And CRP indeed provides a very good response. For example, they suggest the certain guidances, which is that the ideal response would be for the tribunal to deal with AI issues at either at the CMC conference, the case management conference is the beginning of proceedings, and then to direct parties on the use of AI in the procedural order number 1. Because indeed, we all agree that there should be a certain level of disclosure, but so far users, counsel, and even tribunals, they indeed puzzle. What should be disclosed? Who should disclose? At which state of the proceedings? What are the limits of this disclosure? What exactly should be disclosed? And at this stage, the best practice would be that those regulations, the tribunal should be in a driving force, also engage with parties and tribunal should reach certain understanding whether AI could be used, most probably yes, but what kind of AI, whether it's enterprise AI, meaning the servers should be within certain jurisdictions and parties should be in control of the data which is stored, that this data is not replicated, that this data is not used for training of the AI. That's the first guidance. The second guidance, and that the limits of disclosure, that we all agree that some translation-related AI or document management AI, it's not as high risk as when the AI is involved for
drafting like arbitration award, for example.
Exactly.
Correct. Great.
Once the merits I touched, the risks are too high for it to be free city and without any regulations, which should be addressed promptly.
Great. Thank you. Thank you very much for your insight. Leon, if I come to you, Professor Mr. Fakhri mentioned about bias. How can ensure the mitigation of the AI being biased?
Once again, I didn't hear you.
Yeah, so Professor Fakhri mentioned that about the AI could be biased during the use of the AI, and we need to make sure to mitigate this risk. So it will be great to share your thought about it.
Yeah, maybe first thing to pick up also from the previous speakers, recently also regarding the use of AI and how to see whether AI was used, somebody has put the American Constitution into 0GPT and it showed that it's 100% AI generated. Who knows, maybe ChatGPT was already present in the 18th century, but we don't know yet for sure. But yeah, at some point, it will replace probably and cut costs at a certain junior level. We have drafted the rules for the International Games and Esports Tribunal. Also, speaking of transparency, the rules do allow the use of AI. They are binding. It's binding to disclose how and which AI was used, because AI is different and AI is biased, and you see it from the training materials. For example, there is a study from, I believe it's from 2020 or 2021, when AI, and it was ChatGPT, DeepSeek, Claude, and Harvey that were tested. They were fed with decisions by the European Court of Human Rights up till to a certain date, which was a cutoff date. And then after the cutoff date, they were asked for decisions that were already decided to give an opinion on how to decide. And what was interesting is that DeepSeek gave the most precise arguments and most precise quotations from previous cases from the European Court of Human Rights with regard to the decisions that are taken. That gives me back, or leads me back to the question, does it replace the arbitrator? No, it shouldn't replace the arbitrator. It might replace the secretary of the tribunal to handle emails and to handle procedural orders or document production requests, which depending on the AI are dealt very good with. But in the end, it's the arbitrator who's in the seat to decide. So what we will need in future is that the arbitrators are well versed and they have been taught how to use an AI, how to prompt. We have seen recently there is already a first annulment case of an AI-generated award, at least allegedly. It's a case by the American Arbitration Association, where in a dispute with over, I believe, 2,000 pages of submissions and a 10-day hearing, an award was surrendered over Christmas in 15 days. So it's the case name is La Paglia versus Valve. And I believe Anastasia will talk a little bit more about it, but it shows the dangers. What if you miss something? And speaking again of responsibility, it's the responsibility of the arbitrator, if he or she uses AI, to make sure that everything that is cited is correct, that the decision is taken by the arbitrator and not by the AI. And we had such cases already previously, not concerning AI, but concerning the secretary of the tribunal, who sometimes do draft awards. And then it's a ground for annulment. And then we have all the follow-up questions. What happens? How do we decide? Was the award drafted by AI? And if so, how did it influence the decision of the arbitrator? And if it did really influence the decision of the arbitrator, how can we annul the award? And what is the burden of proof? What is the standard of proof? We have really terra incognita here, where we need to establish rules, and we don't have these rules. The arbitration institutions don't have these rules yet. As Anastasia has mentioned, they're just building it up. But this is our task for the future, in the future 5 years. And we have seen that it's a quantum leap between ChatGPT 3, which was 3 years ago, and ChatGPT 5. The questions and the answers that you got 3 years ago and that you get now are just diametrically, like, they're completely different, and the quality is it's a completely different quality. So we need to see how we establish soft or hard law amongst the community on how to use an AI. It's not a question of whether we will use, but how and how to disclose it.
Thank you very much. الشيخ عيسى، بما أنه نتكلم اليوم عن كيفية استخدام الذكاء الاصطناعي، هل ممكن تخبرنا يعني في الوقت الراهن كيف ممكن نستخدم الذكاء الاصطناعي؟ هل نستخدمه في الأعمال مثل ما ذكرت سابقا في أحكام التحكيم، أو فقط في الإجراءات، أو في الأعمال الإدارية؟
استخدام الذكاء الاصطناعي على أرض الواقع الآن يبدأ في العملية القانونية من بدايتها. على سبيل المثال فيما يتعلق بكتابة العرائض، مكاتب المحاماة أصبحت تكتب العرائض الآن وتستعين بالذكاء الاصطناعي. فيما يتعلق بتحليل الأدلة، فيما يتعلق باختصار وقراءة تقارير الخبرة. تقرير الخبرة في بعض الأحيان يصل إلى 1000 صفحة. الذكاء الاصطناعي في خلال دقائق يستطيع أنه يختصر الذكاء الاصطناعي التقرير برمته. ما هو مهم فعلا أنه يكون المتعامل مع الذكاء الاصطناعي لديه ذكاء خوارزمي، وهذا مهم سواء كان محامي أو محكم، بحيث يستطيع أن يحلل ما ينتج الذكاء الاصطناعي. احنا في صراع مع هل نستطيع أن نقيم ما ينتجه الذكاء الاصطناعي، وهذا أمر في غاية الأهمية. لكن من ناحية الاستخدام الآن، الاستخدام من بداية كتابة العرائض التقديم إلى إصدار الحكم، ممكن الذكاء الاصطناعي أن يصدر الحكم، لكن لا يزال العنصر البشري المتمكن الأكثر ذكاء من الخوارزميات، بحيث يقيم صحة الحكم. فهذا واقع. ومثل ما ذكرت، أنا لما أتكلم عن الدخول إلى عصر الذكاء الاصطناعي لا أتكلم كمستهلكين، لكن أتحدث كمنتجين. احنا بحاجة لمكاتب المحاماة أن يكون لديها أقسام في الذكاء الاصطناعي، وحاجة إلى مؤسسات ومحاكم القضاء بأن يقوم لديها مراكز ذكاء الاصطناعي. فبذلك أعتقد من الضرورة أن يتغير الهيكل التنظيمي للمؤسسات. إذا كانت المؤسسة لديها 10 محامين، فأنت بالضرورة بحاجة إلى 3 موظفين تقنيين في مجال الذكاء الاصطناعي. في مجال المحاكم لابد أن يكون هناك قسم لمن يستخدم الذكاء الاصطناعي لمساندة أمانة السر ومساندة القضاء. في مجال صناعة القرار على المستوى التشريعي، الآن ليس خافيا على أحد بأن التشريعات تصدر في الغرب باستخدام الذكاء الاصطناعي، وأصبحت أكثر جودة وأكثر تقنية وأقل أخطاء. احنا نتحدث الآن عن تشريعات تفسير واحد فقط للنص. نتحدث عن التشريع الذي هو بمثابة معادلة رياضية في طريقنا إلى الانتهاء من عصر أن النص يمكن أن يفسر مرتين. الذكاء الاصطناعي يستطيع أن يكتب لك نص له تفسير واحد فقط، وبالتالي هذا يعزز صياغة العقود، يعزز تفسير الأحكام، يعزز بناء القدرة التحليلية لبناء منظومة تشريعية متكاملة.
نعم. أشكرك الشيخ عيسى. كنت أقرأ في فترة قريبة في حكم من محكمة قطرية يعني فيما يتعلق بأنه أحد من المحامين استخدم ال AI في إعداد مذكرة، والمذكرة أرفقت سوابق قضائية ليس لها وجود. هذا يدل انه الان احنا بعدنا غير مستعدين، وانه ايضا المدخل البيانات او المستخدم الذكاء الاصطناعي لابد ان يكون حذر، جدا حذر، كون انه تصير بعض الاحيان لخبطه.
انا خلينا نقول مصطلح ربما باللغه الانجليزيه، يعني هناك مجموعه من العاملين في الحق القانوني يعيشوا مصطلح باللغه الانجليزيه يسمى state of denial. هذه حالة الإنكار، هذه حالة غير صحية وتخرج المنظومة يعني عن مسارها الطبيعي. يعني المنطقة اللي يدور في المنطقة احنا لأنه بعيدين عن المنشأ الذكاء الاصطناعي، في محاولات كثيرة وعديدة من يعني في مجال صناعة القرار تحاول التقليل من شأن الذكاء الاصطناعي، وهذه ظاهرة غير صحية بالمطلق. كتبت عن طريق الذكاء الاصطناعي أو غير كتبت، فالمحامي هو يتحمل المسؤولية الأخلاقية.
جميل. نرجع للبروفيسور، ما هي قراءتك لاستخدام الذكاء الاصطناعي في المجال القانوني في مختلف مجالاته سواء القضاء أو التحكيم خلال ال5 أو 10 سنوات القادمة؟ أين ترى الذكاء الاصطناعي؟
قبل أن أجيب عن هذا السؤال أذكر فقط أن هناك مع ذلك تظل بعض السياقات التحكيمية التي الاستعانة فيها بالذكاء الاصطناعي يجب أن يكون أو يظل الآن ومستقبلا نسبيا أو حتى يستبعد فيها. مثلا عندما يتعلق الأمر بتقييم المصداقية، مصداقية الأدلة، مصداقية الشهود، الحكم على النية المبيتة إلى غير ذلك، هذه أمور لا ينفع معها استخدام الذكاء الاصطناعي لأنها تتعلق بسلوك أو مشاعر أو أحاسيس بشرية عند القاضي، عند المحكم، عند الأطراف إلى غير ذلك. يعني أيضا مسألة مهمة جدا لا يمكن أن تترك في مجال التحكيم، أن تترك للذكاء الاصطناعي، وهي تعليل القرارات التحكيمية. لأنه الجزء المتعلق بالتعليل في القرار التحكيمي يرتبط بقناعة المحكم، وكيف بنى هذه القناعة، على ماذا بنى هذه القناعة. هذا الأمر لا يمكن أن يستشعره الذكاء الاصطناعي، وبالتالي أعتقد يجب أن يظل خاص بالمحكم. أمر ثالث مهم أيضا من الصعب أن يترك للذكاء الاصطناعي، وهو تفسير بعض النصوص أو القواعد القانونية التي تكون ذات صبغة عامة أو لها أكثر من معنى أو لها معاني مختلفة متناقضة، أيضا يجب أعتقد أنها تترك للمحكم لكي يفهمها. الآن فيما يتعلق بالمستقبل، دراسات كثيرة تعمل على هذا الموضوع بشكل عام فيما يتعلق بالذكاء الاصطناعي، ما يتعلق بالذكاء الاصطناعي في المجال القانوني، ما يتعلق بالذكاء الاصطناعي في مجال التحكيم، وتذهب كلها في اتجاه أن هذا الذكاء الاصطناعي لا شك سيتحول
من مجرد عامل مساعد إلى عنصر إجرائي معياري، بمعنى سيصبح يعني لن نستطيع تجاوزه أو سيفرض نفسه أكثر. أولا فيما يتعلق بكل الفوائد التي يقدمها ستنتقل وتتطور وجودتها تتطور لأضعاف الأضعاف. كل ما تحدثنا عنه من تحديث البيانات، من تحليل البيانات، من يعني دراسة كل عناصر القضية بما فيها الوقائع إلى غير ذلك، حتى سيصل الأمر ربما إلى إدارة الجلسات بما فيها إصدار الأوامر يعني أحيانا الإجرائية الروتينية التي الهيئة التحكيمية غالبا ما تصدرها بشكل مستمر، وأيضا كتابة المحاضر إلى غير ذلك. لكن أهم تطور يمكن أن يحدث يتعلق أيضا بالمحكم. يقال أو الدراسات كلها تذهب في اتجاه أنه سنصبح أمام ما يسمى بالمحكم المعزز augmented arbitrator، بمعنى أنه هذا المحكم ما يقدم له الذكاء الاصطناعي من أدوات من مساعدة ستجعله أكثر حنكة، أكثر جودة، أكثر كفاءة إلى غير ذلك. أهم عنصر في الأخير يتعلق بالخصوص ما يتعلق بالجانب القانوني. الآن نحن في وضعية لا زلنا لم نحسم فيها الموقف من استخدام الذكاء القانوني في المجال القانوني. تحدثت منذ قليل عن الحالة القطرية، حالات كثيرة في الولايات المتحدة
موجودة نعم في
كل وقت تظهر هذا النقاش سيحسم لصالح الذكاء الاصطناعي طبعا ضمن وفي إطار الضوابط التي تحدثنا عنها. سننتقل من وضعية القواعد الاسترشادية، القواعد المرنة، إلى القواعد القانونية الصلبة، وبالتالي ستضطر التشريعات الوطنية المتعلقة بالتحكيم إلى تعديل نفسها وإدخال أولا الاعتراف بإمكانية اللجوء إلى الذكاء الاصطناعي، لكن مع تحديد ضوابط للحفاظ على السرية، ضوابط للحفاظ على الحياد والنزاهة وعدم التحيز.
جميل.
والبعض يتحدث أيضا عن مسألة أخرى قد تبدو يعني متطورة جدا، تتحدث عن المحكم التكنولوجي.
نعم.
اليوم بعض القوانين في الدول مثلا المملكة العربية السعودية تشترط في المحكم الفرد أو رئيس الهيئة التحكيمية أن يكون حاصلا على الإجازة في الليسانس في القانون أو الشريعة. غدا يقال أنه ممكن أن يكون هذا الشرط يستبدل بأن يكون رئيس الهيئة التحكيمية وأحد أعضاء الهيئة التحكيمية محكما تكنولوجيا، بمعنى خبير في مجال الذكاء الاصطناعي.
صحيح. هو مستقبل طبعا غامض مخيف، وقد يكون أيضا جميل وسهل للمحامين والقانونيين. أكيد سنرى المزيد من الذكاء الاصطناعي، وأكيد هتكون إضافة إيجابية. نحن لابد نكون إيجابيين. انتهى وقتنا، حديث شيق، ولكن نريد نعطي الحضور وقتهم. تفضلوا. تفضل أخ. أعتقد الميكروفون موجود.
بسم الله الرحمن الرحيم، الحمد لله رب العالمين، وصلى الله وسلم على سيدنا محمد وعلى آله وصحبه أجمعين. القاضي أحمد بوصافي، قاضي استئناف تفتيش القضائي، تلميذ الدكتور رياض فخري. ومداخلتي فقط هنا أتحدث عن الموضوع، ما أريد أقول أنه شيء من تناقض، لكن بقدر ما أنه يجب أن نأخذ بالحسبان عدة محاور. المحور الأول أن خصوصية التحكيم تتركز في من ضمن أساسيات ارتكاز التحكيم الخصوصية والسرية. في المقابل الذكاء الاصطناعي يعتمد على العموم، يعني جمع المعلومات. الجانب الآخر الحكم التحكيمي هذا الذي سيصدر يخضع للرقابة، وهو من ضمن الخطوط العريضة النظام العام، وهي من الأمور التي لم تحسم حتى الآن بشكل واضح في أغلب الدول. وهناك النظام العام الدولي، ما يسمى بالنظام العام الدولي، وبالتالي حتى في سواء في الدول الأوروبية أو الفقه اللاتيني أو الأنجلو ساكسوني أو معنا في دول شرقية وفي آسيا وفي غيرها، لم تحسم في كثير من المسائل في هذا الجانب. أيضا عندنا ما يسمى بالرقابة على الحكم التحكيمي، اللي هو مسألة تدخل القضاء في مسألة. فإذا كانت التشريعات نفسها أو أنه ما زالت هناك، ما أستطيع أن أقول هو، لكن ما زال أنه القضاء له كلمة. علق أيضا النقاش التي طرحت في الأوراق العمل السابقة، سيادة الدولة إلى غير ذلك، النظام العام. فهذه كل الاعتبارات يجب ان تؤخذ عندما نجي نتكلم عن بكلمه عامه هل ناخذ بالذكاء الاصطناعي في التحكيم ام لا. وكان السؤال الاول الذي طرحه المدير الجلسه الاستاذ ناصر، يعني هو دخل في كتابه المسودات على طول، مسودات حكم التحكيم، فهو يعني هنا في اخطر حاجه في الحكم او في التحكيم نفسه. فبس مداخلتي هنا استفساري، يعني هل هو نقدر ان نحن نضع ضوابط تحمينا، بمعنى انه اليوم انا لما يعني احط التقرير الخبير هذا المكون من آلاف الصفحات للذكاء الاصطناعي ليقرأ، يعني باختصار خلينا نقول ندخل في ضوابط اللي اشار اليها الدكتور رياض فخري، مساله انه الحفاظ على السريه والخصوصيه بمعايير تشريعيه ومعايير ايضا تكنولوجيه نفسها، بمعنى انه اذا وضع هذا التقرير في هذا التطبيق معين لا يتم تسريبه الى امر اخر. بالتالي نقتصر على مساله الجانب المساعد الفني خلينا نقول للمحكم او ما شابه ذلك من مسميات. فطرح السؤال يعني بحد ذاته انه هل نحن نقوم بالاعتماد على الذكاء الاصطناعي؟ سؤال كبير جدا في تفاصيل كثيره جدا مع الاخذ بالحسبان المعايير التي سبق ذكرها، وشكرا على الاستماع. بارك
الله يحفظك. You want to talk about it because it's about confidentiality, so this is your part.
Thank you. It's a very good question, and I think that transparency is not an enemy. It's a friend of confidentiality and integrity of the proceedings. Because if the tribunal would be empowered to regulate those issues, you mentioned expert reports. If expert report is on 1,000 pages, there could be a good reason for that. And if we would allow the tribunal to reduce it to a short summary, then it should be the short summary which is filed at first place, because there is a huge risk that some nuances would be lost in those high-level summaries. And in preparation to this panel, I talked with acting arbitrators, and their main takeaway now that the discussion is not hypothetical. It is true, but for arbitral tribunal, the use of AI makes sense only as a tribunal secretary function, rather for chronologies, for writing emails faster, for proofreading, but definitely not for outsourcing merits of the case and expert evidence or strategy of the case or evidence of witnesses of facts, when a lot of commonplace with emotion or mental impressions should definitely not be outsourced. And for that, transparency is very important. Again, regulation, transparency, rules of the game, when humans in the loop, that we are not relying on AI because it's well read and well written. Humans should be in a driving seat, because otherwise the whole arbitration and the adjudication mechanism would be just lost in all nice drafting instead of resorting to merits and a good apprehension of merits.
وإضافة لما ذكرته الأستاذة نيسا، يوجد مكاتب كثيرة قامت بتطوير برنامج ذكاء اصطناعي خاص بها. يعني مثلا كمكتبنا نحن عندنا برنامج الخاص، المعلومات اللي تدخل فقط تبقى في المكتب، وكثير من الشركات تقوم بهذا، انه تقوم بتطوير برنامج يكون خاص لها. استاذه
السلام عليكم. عهود المعشري، شريك في WR. سؤالي، هل التشريع العماني يعني في ظل الترويج الحالي للذكاء الاصطناعي واستخدامه في التحكيم أو أيا كان في مسار الأعمال القانونية، هل تشريعنا العماني جاهز لمعالجة أو تصحيح أي أخطاء قد تقع في ظل استخدام الذكاء الاصطناعي؟ لأن نحن عندنا إشكاليتين الآن. أولاً أن الذكاء الاصطناعي يعتمد على المدخلات، وغالب يعني المعاملات أو أمور الخاصة بالأعمال القانونية هي باللغة العربية إذا أتكلم عن سلطنة عمان. فالمدخلات الموجودة في الذكاء الاصطناعي باللغة العربية ما زالت غير كافية، ومثل ما ذكرت أستاذ ناصر الأخطاء تحدث يعني الذكاء الاصطناعي ممكن يشير إلى مبادئ قانونية غير موجودة أو إلى مواد قانونية خاطئة أو يدمجها مع دول أخرى وهي غير منطبقة للقانون الواجب التطبيق. الإشكالية الثانية في هذا المجال أن مثلا قانون التحكيم عندنا لإبطال حكم التحكيم لم يعطي صلاحية مثلا أن يكون أحد أسباب البطلان الخطأ في تطبيق القانون أو الفساد في الاستدلال. فهذا هو سؤالي. شكرا.
شيخ هيثم،
يعني هل نحن جاهزون لتطبيق الذكاء الاصطناعي؟ كل العالم ليس جاهز الآن، لأن الذكاء الاصطناعي بالضرورة يستلزم منظومة كاملة. بمعنى أنا أتحدث ربما نصل إلى عام 30 قانون الإجراءات سوف هل نحن جاهزون لتطبيق الذكاء الاصطناعي؟ لا. هل مطلوب منا تطبيقه الآن كعنصر رئيسي؟ هو كعنصر استشاري. احنا مقبلون على مرحلة والتوقع أن يكون في عام 2030 إنه كل القوانين الإجرائية والموضوعية تصاغ بالذكاء الاصطناعي. الفجوة الموجودة الآن إنه هذه القوانين صيغت بعقل بشري. العقل البشري هذا يعني أقل قدرة من الذكاء الاصطناعي. هنا يحدث الآن احنا نتحدث عن تناقض بين عقلين، عقل متقدم وعقل. فالذكاء الاصطناعي سنصل إلى مرحلة كل التشريعات، وبالضرورة يجب أن تكون كل التشريعات مثلا في السياق المدني، قانون في عمان معنا قانون الإجراءات المدنية، القوانين الموضوعية سواء قانون الاستثمار، قانون التجارة، عدد ما شئت. في هذه المرحلة سنقول فعلا أن الذكاء الاصطناعي وصل إلى مرحلة متقدمة، لكن الإشكاليات قادمة. بس أستاذ يعني أؤكد لك على وجه الجزم واليقين السفينة تمضي. إذا لم ننتج الذكاء الاصطناعي سنجبر على استخدام منتج من جهة أخرى.
هو عموما يعني الحكم التحكيمي عندما يصدر في الوضع الحالي لا يقال أنه صدر باستخدام الذكاء الاصطناعي أو يشار فيه للذكاء الاصطناعي غير ذلك، وإنما ينسب لمحكم وبالتالي ينسب لبشر، وبالتالي إذا وجدت فيه أخطاء سببها يعود إلى استخدام الذكاء الاصطناعي ستعتبر أنها أخطاء تعود للمحكمين أو للهيئة التحكيمية. إذا كانت تشملها لائحة أسباب البطلان ستؤدي إلى بطلان الحكم التحكيمي. إذا لم تكن تشملها هذا أمر آخر. النقطة الثانية المتعلقة بسبب فساد في التعليل واستخدام القانون، حتى أن لم يوجد في لائحة أسباب البطلان في القانون العماني، لكن هناك وسيلة أخرى قد تشمل هذا نقطة أيضا، وهي مسألة النظام العام يعني التي تبقى سلاح في أيدي القاضي، أحيانا تشمل تفسير النظام العام. هذه المسألة أيضا. شكرا.
Yeah, if I may add to that one, 2 points, not Omani law, but speaking of public policy. Yes, the public policy is a tool to regulate AI and to see how decisions are taken and whether the decisions taken with the help of AI do indeed violate public policy. But to be completely transparent, if one wanted to have awards which are enforceable, which are also assisted by AI, in my opinion, the approach would be the arbitrator or the parties who are using in an arbitral process or even in litigation AI should include the prompt that they have used, the documents that they have used in that prompt. Speaking of Harvey, which does guarantee, for example, data protection and secrecy and confidentiality, and the output, what the prompt gave, and how the party has modified the answer by the AI. And having this, of course, this is additional information to the award or to the submission that you don't have to read, or you would read, and which would inflate, of course, the submission. But this would give you a transparent way of how to deal with AI. And as a matter of fact, also coming back to the universities and to the scholarly works, many universities across the globe have adopted AI regulations, which exactly propose that if you write a thesis, be it a bachelor thesis, a master thesis, a PhD, your habilitation, that you have to have an annex saying, I have used ChatGPT, I have used Grammarly, I have used the AI function of Adobe Acrobat to summarize the 1,000 pages book. And then you give the prompt and what you have used. So you're completely transparent. And this also gives you the opportunity to see whether AI has or has not influenced your decision.
Thank you very much. I think our time is up. So thank you everyone for your input. It's an interesting topic. For sure, there is room to develop the AI. The government spends millions and billions to develop AI. Thank you again. And we are the last session. شكرا جميعا على الاستماع واتمنى لكم يوم او امسيه فيما بعد العشاء طيبه باذن الله. عذرا عندك كان سؤال بس انا بجيك شخصيا وبجيب المتحدثين معنا. منك العذر. الله يحفظك.